Yes.
May I, my lords, coin leave to mention a contempt application before this bench. Original principal order was passed by this bench.
Your Lordship's kind indulgence to mention one appeal, my lord, along with application under Group 7.
Application, yes.
Group 2 application.
Yes.
For correction.
Of our order. When order was passed,
Leave without certificate.
when order was passed,
Order was passed 10th May 2000. 10th May.
my principle is that if the normal period of limitation has expired, even if you have applied for certified copy,
Well, what
I
problem?
never gave a single.
Well, it is a contempt matter. Let me say.
I never gave a single.
What is the problem here? In some of the bench, honorable benches,
Why you did not come for earlier?
well, let me. Some of
But the decision would be the same.
well,
sir.
let me say. I've also wrote to the Honorable Chief Justice this matter.
Please.
Well, some of the honorable bench allow without on this harbor copy.
Yes.
Some of the bench doesn't do not allow the expect the certified copy. Therefore, if there is an interlocutory order, even if one buys a certified copy, then he is facing the problem. So therefore, if this is a contempt matter, my lord, so therefore I'm waiting for the last. Whenever I inquire, it is told that the file is lying in the department. It is in the chamber of the honorable judge.
Huh?
That is there. That is there. Even well, that is there. That is there.
But anyhow, sir, my principle is, which is very uniform to all. I have not granted a single leave to any member of the bar. Not once. You cannot come with any solitary instance where we have given the leave after the normal period of limitation. You may have a persuasive value,
No,
of
I'm
appearance,
not.
but
I will not
you ought
ask.
to have come immediately.
Well, there are
Could have come immediately after this. You have this other copy. You could have come in the month of May. You could have come in on the reopening 10th. No problem. But you waited for such a long time after normal period, then we normal
otherwise
not
because
allowed any.
why I am not, because my lord knows better than me that if there is interlocutory order.
Why you did not come earlier? You are in the same position as you were in the month of May. Why you did not come?
Hello.
I grant always, even a 1 day before, I granted the leave.
My lord, why I'm not happy?
Sorry,
My
we
lord,
can't.
why? Because there are too many orders passed. So thereafter, other orders also passed. I can come with that order also because the route is there.
No difficulty.
No, the problem is there, my lord. This matter is a contempt matter. So therefore, my lord knows that if the court passes any order without jurisdiction, Section 19.
Sir, everything is there. You have one of the best case on law. Let us presume. But still, I will not deviate from a uniform rule.
Then, my lord,
No.
subsequent.
Why you did not come earlier? You could have come. You had the same situation. After the order was passed, you are in the same situation. Why you did not come earlier? We would not have applied our mind and direct you to file if it is within 1 month from the date of the order. No problem. What the other members will what the other members will have.
An application on the same identical matter, it was filed 2 months back on the same order. This is an application.
No difficulty. You have filed it, application, it will appear.
Then, well, I can-
Every application.
Lord, may I make a humble submission? Lord, that contempt matters land loser, my lord was not there, therefore the matter could
Yes.
kindly take up on a particular
We'll
day,
take
my
up
lord,
because
otherwise
of the
we are in
contempt,
trouble.
because 2 weeks he was there in the circuit
That's
bench.
right, Lord.
We'll
Lord,
take up.
will kindly
Don't worry.
keep it in mind, 148, my lord, today's.
We'll take up.
Well,
Don't worry.
let me
Lord, please.
permit to change this order and annex another order that is the latest order.
No. We can't give you. You do whatever you want. Let's call the list.
My lord, with the leave of justice Vishwas, my lord, I am mentioning a matter before your lordship, my lord. A matter came up for hearing before your lordship on 20th of December 23. Order 41 matter. My lord, this particular matter, my lord, when the matter came up for hearing, my lord, we appeared with my learned junior on behalf of the respondent. since there was no representation on behalf of the appellant, your lordship, after seeing the note, my lord, your lordship directed to put in the stamp duty that is deficit, and in default, it will be dismissed. But not deposited by the appellant. So the difficulty is, my lord, our name has gone down as the appellant. Now
No, wrongly gone.
uh,
Correction,
yes.
say that one word. You want a correction of the order. Sitting with us,
No, with Justice Madhuresh Prasad.
we'll sit together.
Your Lordship, with the kind leave of His Lordship, Honorable Justice Proceedings, Vishwas, may I mention a contempt application, Your Lordship, when His Lordship was sitting with His Lordship, Honorable Justice Madhuresh Prasad, Your Lordship, for inclusion, Your Lordship.
Contempt.
Yes, Your Lordship.
স্যার আমার একটু কথা বলবো স্যার স্যার আমার একটা মামলা আছে 1506
কোনো ভুল হতে পারে না, accept him. ফাইলটা বার করবি, ওরই দেখা। Yes,
স্যার আমি একটু কথা বলবো স্যার আমার একটা মামলা আছে 1506 ম্যাট 9 বছর ডিভিশন বেঞ্চে আছে স্যার
কি
এ
মামলা?
পর্যন্ত তুলতে পারছি না
কোন মামলা? কিসের?
প্রাইমারি স্কুল কাউন্সিল প্রাইমারির সঙ্গে আমার স্যার
আপনি কি অ্যাপেলেন্ট না আপনি
আমি
রেসপন্ডেন্ট?
এটা আমার ওই প্যানেলের নাম আছে সবকিছু আছে
জিজ্ঞেস করছি আপনি কি অ্যাপেলেন্ট এই মামলায় না
স্যার
রেসপন্ডেন্ট?
আমার উকিল বাবু এখন মামলাটা ছেড়ে দিয়েছেন
বুঝলাম, কিন্তু আপনি অ্যাপেলেন্ট না রেসপন্ডেন্ট এটা বলুন। আপনি অ্যাপিল ফাইল করেছেন না আপনার বিরুদ্ধে appeal file
আমি
হচ্ছে?
স্যার অ্যাপিলে
আপনি অ্যাপেলেন্ট
হ্যাঁ স্যার
দিন
এই
লিস্টটা।
মামলাটা কাইন্ডলি একটু দেখে দিন
দেখো ফাইলটা নিয়ে। Yes, call the list.
Jalpaiguri matter. Item number 1.
Hello, this is my appeal.
তাদের সঙ্গে এই কি স্কুলে না?
My lord, if your lordships kindly recollect, my lord, I placed before your lordship a judgment of the Honorable
Along
Apex
with
Court.
the other, এটা কি একটাই এসছে কেন? Others কি আছে?
My lord, I am giving the
No,
number.
no, it's a relating to group 2.
Group 2, my lord.
Where are other matters?
Other matters, my lord, I am giving the numbers, my lord.
Please give. Hello, এটা বলেছি, it is to be heard in the specific by the regular
Are assignment in order? My lord, if it can.
Give,
Yes,
sir.
my lord.
Madam, give.
My lord, if it can be posted after 2 weeks, my lord, because the learned
Sorry.
Advocate General is sick, my lord, so probably they will take time.
Yes, the matter has come up by way of an assignment with an indication that
And
assigned হয়ে এসছে এত সিও।
I am appearing, my lord, proposed respondent number 4 in title appeal number
Title
36
appeal,
of
it is a
87.
CO,
This man,
civil revision.
yes, civil dimension number was registered,
Appeal when
registered, my lord, on the basis of the LCR
no, no, এটা
sent from the landed district
Official
of Purulia
reference
for
number?
opinion of this honorable court.
what is the point? What is the point involved?
For my lord, according to instruction, my lord, the land belongs to the scheduled
Oh,
property.
I am not asking, sir, what is the point of reference? It is a special bench. It has been referred to a special bench, so there must be a point of reference. You don't know.
Reference, my lord, for the opinion of this honorable court,
For what?
according to the instruction, as the land was transferred to the lands belong to the scheduled tribe, but transferred to beyond the scheduled tribe. So this transfer may be void or not.
Post 1969, so far of the transfer of costs. Post provisions. But see, has been explicitly. But the children are put in see that does not go to state cannot override the provision. Children are. Therefore, the same for the opinion.
But in the meantime, so many appellants died, also respondent also died.
Stairs.
Yes, it's administrative notice was issued, but I do not know in the my lord, in connection with the TA.
Item delivered, it says. Then item returned with the remark deceased. No, so many, no, only one.
No, Mala, I am concerned on the Mala TA 46 of 87. Appellant was Motilal Mahato, Mothur Mahato died. And appellant number.
I have seen one article of sole appellant of TA 62 of 87.
I am concerned TA 46 of 87.
62 is deceased. Your matter, everybody has been served.
Yes. But TA 46 in connection with appellant number Motilal Mahato and deceased. Motilal. But Mothur Mahato, Bir Bahadur Mahato and Nilkanto Mahato died. Only one appellant is alive, Sharat Mahato.
46 you are talking about. There are 4 persons who have been served. Item delivered.
4 person means the name Motilal Mahato deceased.
I do not know.
Yes, Motilal Mothur, Bir Bahadur Nilkanto died. TA 46 of 87.
46 it is said.
And respondent 5 and 6 also died. Only respondent number 4 is alive.
Dago, the matter is listed today for listed today having assigned to this bench by the Honorable Chief Justice.
number 2, I am for the appellant. This is the assigned matter before your lordships.
Item number 2, I pay for not being coming on.
We are the intervener, Lordship.
On 8th March 2024, there is a direction, my lord, upon the my lord. Purbo Mendipur district.
1 minute. Let us see. This
Yes.
has come up for the
Yes.
first time after assignment. Let us see why it has been assigned. There is no order of assignment.
It is released on 28 June
I do not-
2024.
I do not, 20th June, when it is released. The objection is in the compliance. Oh, the matter is released from. It's not an assignment. It was a part heard and that was released.
My lord has regular determination over this matter.
That is
Subject
what
to
is-
correction.
Therefore, this matter has come up from the office of the Honorable Chief Justice. With a direction to place the matter before the bench having a regular determination. In such view of the matter, let this, in such view of the state of affairs, let this matter be listed after 2 weeks.
Obliged.
Lordship, we have made an application. I
Hey.
think.
You give only your name,
Lordship.
not the name of Diyada Firat.
And they're all
You are asking for an adjournment on whose ground? On Mr. Giri. Don't record the name of Mr. Giri. We will not record his name. He is unwell. He has not come to court. Sorry.
Lordship, the
Only your name.
ছেড়ে দাও না কি হয়েছে ছাড়ো না। সব তারপরে হ্যাঁ সব হবে
Give your name only.
আপনারটা শুধু দিয়ে দিন
Hey, Samiran Giri's নামটা record করো না। Next.
obliged my lord. Good.
grateful.
Item number 3,
Lord, I appear for the appellant in this matter, my lord.
Well, I am for the
My lord,
petitioner
this matter was
respondent.
released, my lord, on 22nd of July and now has been specially assigned before this bench, my lord.
পরে দিয়ে পড়বো
পাস করেছিল।
Respondent 1 করতে পারতিস তো? Respondent 1 লিখিস নি তো? না। Respondent 1 টা বলে দিন। Respondent number 1 করে নিন। কি নেই?
Please. My lord, along with the appeal, there are few connected applications. My lord, one application, if lord,
Any impediment for this bench?
No.
it's a, my lord, writ appeal, my lord, residuary.
Everybody is appearing. To
I am
be
for the
appealing
respondent number
this matter, these applications after a week,
Yes, my lord.
On 13th, my lord, subject to lordship consent. On 13th, my lord,
13th.
13th, yes. 13th, yes, my lord.
The matter
item number 4,
My lord, item number 4, I am for the
What
respondent.
correction, sir?
Correction in the name of the surname. My name is Vishnupriya Khatua instead of Vishnupriya Ghatua.
ওইটা না
না, তুমি নয়, আমি বুঝে গেছি। Where is the name?
My name is Vishnupriya Khatua. K-H-A-T-U-A. But-
EHA,
KHA Khatua.
Tiki, then where
No,
is wrong?
No, this is the Ghatua. GHA Ghatua.
Khatua.
Yes, yes.
देखो बाबू खाटुआ ना खाटुआ আগে দেখো কার অর্ডার আছে আমাদের বেঞ্চে না অন্য বেঞ্চের অর্ডার আছে দেখো আরে অর্ডার শিটে দেখো লাস্ট অর্ডার কোথায়
Order dated 16 July 2024, my lord.
July order is passed by whom?
Before your lordships. হ্যাঁ আরে এটা খাটুয়ার জায়গায়
Correct.
খাটুয়া
The Khatua, it should be Khatua.
খাটুয়া
Correct.
হ্যাঁ ওটা কে আর জি
EHA হবে।
জি কে
EHA হবে না Next.
Order number five, my lord, for the respondent. I mentioned the matter before your lordships, my lord, to that effect that, my lord, one order was passed, my lord, in the writ petition, also, my lord, in the appeal, subsequently Supreme Court, affirming the, my lord, alteration from, my lord, B.Ed to D.El.Ed. The matter instant appeal, my lord, CAB on, my lord.
He wanted to say, so bring something more.
I tell your lordships,
I do not know whether that has been
my lord,
brought.
kindly have a look at the Supreme Court judgment order. My lord, that was against an interim order.
Was,
Absolutely.
I do
My lord,
not
the
know.
honorable Singh,
After the final disposal is made, if some clarification has been done, then we'll have to. If this order is passed prior to, Supreme Court order is passed prior to the final order, then he has no case. Because any interlocutory order by way of clarification also merged with the final order.
No, this is not a case of clarification, my lord.
clarification,
I
my
tell your
lord.
lordships,
What has
my lord,
happened, my lord? On
Not a
9
clarification.
July, my lord, your lordship was pleased to CAB the matter, appeal. Now, my lord, I got the copy of the order passed by the Honorable Supreme Court, whereby, my lord, the appeal preferred by the West Bengal Board of Primary Education is dismissed on the ground that, my lord, issue is, my lord, there, my lord, the candidate who are B.Ed, my lord, they altered, my lord, their educational qualification to D.El.Ed to participate in the selection process of 2022.
No, this is what is in relation to this matter.
No, I tell your lordships.
Yes, my lord, yes. Because, my
Yes.
lord, in the
No,
our
in
writ
case
petition,
of Sumanto Kole,
Shumanto Kole, my lord, the alteration, my lord, here, my lord, we are the DLED candidate. We altered our application, my lord, in the instance of the West Bengal Board of Primary Education, they issued a notification of in the month of June 2024.
Or have your lordships seen the Supreme Court order?
the Supreme Court order I am looking at.
At the last
Your lordships
page.
kindly have a look at
I've
this.
seen that however we have a note that whatever interim relief is granted
Exactly,
by the
I-
High Court is already made, subject to the final outcome of the writ petition, and such a position would obviously prevail in the litigation.
My lord, paragraph 3 also, my lord.
There is no paragraph 3.
Yes, your lordship,
Oh.
first page. As the matter is still pending before
We are
the
not
High Court in
inclined to
which
interfere.
my lord, that's the main matter your lordships heard it. I tell your lordships. There are several writ petitions. First writ petition interim order was issued. We preferred an appeal, we lost. Against this, board preferred an SLP.
Dismissed.
My lord, dismissed. This is an interim direction. But the appeal we have preferred before your loss is a final decision. That's the difference. And this is
The
one
appeal also
difference.
dismissed, my
And factually there are difference.
Well, appeal also dismissed, my lord, and
It's
extra order.
different.
Kindly see, my lord, the last, my lord,
What?
just, my lord, appeal court's order I have attached.
Just an interim order.
No, appeal is dismissed.
Where
Kindly see,
appeal is dismissed.
kindly see, my lord, kindly see, my lord, page order dated 10th May. I attached 10th May, just before the Supreme Court's order. Kindly see the appeal.
Against this order, Supreme Court passed an order.
Kindly see, my lord, accordingly the appeal and application.
This appeal was an interim order against.
Uh-huh.
That's the point.
Dismissed.
This was passed on 19/7,
Exactly.
and this appeal was dismissed when
Appeal
10th
dismissed
May.
on 10th May.
much before.
Huh.
How can a Supreme Court? Nobody
Well, I
informed.
established, my lord.
No, nobody informed that in this matter, Sumanto Kole, on 19/7, the High Court has already disposed of the appeal, but the impression was given that the High Court is still insisting of the matter, because this is what it says
My lord,
In
writ petition is
paragraph
still pending.
3, that as a matter is still pending before the High Court in which the interim direction is issued, we are not
Exactly.
inclined to interfere. That means this matter is MAT 533. If the MAT 533 was already disposed of on
10th May.
10/5, then
But I place
Supreme
this
Court should be
judgment before
apprised
you.
of.
I place this judgment before your lordship. That's why the Honorable Supreme Court, my
No, no,
lord,
we'll make a
admitted the
clarification that
ad-
it was already, nobody pointed out to the Supreme Court that this matter was already disposed of on 10/5.
No, my lord, I tell you, writ petition is still
regarding
pending.
alteration of the qualification.
Please, I do not know. This, what was the writ? Oh, this was a MAT.
Matt,
MAT.
it's a different writ
Oh,
petition.
no, no, not.
No,
Oh,
It is between West Bengal Board of Primary Education
and Shumanto
versus
Kole.
Sumanto Kole and others.
that's one, but what your lordships heard, that's a
Oh, we
different.
are not. We are thinking about it. And the writ petition is still pending.
Still pending. That's a different matter.
Not different matter. Anyhow, the points are still-
Alteration,
No, point is
the
different,
issue,
I
my
tell
lord,
you,
regarding
factually different.
alteration of the candidate to
Factually
their
different.
qualification from B.Ed to D.El.Ed.
whatever.
Obliged, my lord.
After Supreme Court judgment, what remained? The writ court will go beyond it.
The matter is CAV, my lord.
Whatever.
Please.
Unnecessarily you have. Yes.
Yes.
This matter was, though the matter
Item number 6.
Yes, call.
Number 6, correction. Item number 7.
Seven, I am for the Malad appellant.
Decide.
My lord, I am appearing led by Mr. Supriya Chattopadhyay, my lord, on behalf of state.
Matter relates to Malad, the compassionate appointment. Petitioner's appellant's father died on 8th October 2010, Malad. And he made an application on 17th 11 2010, Malad. Thereafter, Malad, the school took a resolution for to recommend his appointment. Then, Malad, the DI in 2013, DI could not take up the matter because, Malad, the PPO was not issued at that time. Then PPO issued, Malad, on 9/6/2024. By 2014. Sorry, I beg you. 2014. Then, Malad, DI took the decision and rejected my prayer for compassionate appointment on the ground, Malad, 2009 rules has come into effect, and 2009 rule regarding financial criteria as per rule 2022, Malad, 20. Malad, there was a explanation regarding financial criteria. Though whether she is suffering from any financial died, Malad, 2008 October 2010.
8
October
2010.
10. He made application on 17th 11 2010.
And when this 2009 note, the
Yes, sir.
rule came,
2009 rule came, Malad, on
9th July 2009.
9th July 2009.
9 July
2009.
Yes.
And in the rule, Malad, 20, Malad, there is the procedure for compassionate appointment.
Where is that rules of
No,
2009?
May I hand?
Something is annexed. This is also
Yes,
annexed.
Malad, the annex, Malad, one page, Malad, missing in my appeal, Malad. That's why, Malad, is handing up the book, Malad.
9 July 2009 circular notification is here.
Yes, Malad. In the here, Malad, it is page, Malad.
Where is that?
একটা
That
পেজ
is
নেই
104,
ওটা।
Malad. Page 104, Malad. The explanation.
একটা পেজ নেই ওটা।
But there is one, I beg your pardon, Malad, one page.
One page
Malad,
is missing.
That's why I hand him the book, Malad. That's a copy. Didn't sir?
একটাই তো বইটা দিয়ে দিলে আমি কি করে দেবো? আপনি কোনটা দিয়েছিলেন? 2009 আরে আমার কথা তাই তো বই।
Malad, before that, Malad.
Same আছে?
Malad, page 8.
ভলিউম আলাদা হলে পেজ মিলবে না। আপনি কোনটা খুলে দিয়েছেন? হ্যাঁ, আমার হেডমাস্টার মেলে মিলবে না, পেজ মিলবে না।
Page
জিনিসটা
আমার
একই
তো
পেজ আলাদা।
আমার তো ম্যানুয়াল এডুকেশন ম্যানুয়াল।
কি চাইছেন বলুন, আমি খুলে দিচ্ছি। এই তো রুল 20, রুল 20 চাইছি। এখানে পেজ মিলবে না, 520।
বইটা দিয়ে দাও আর এই বইটা দাও, ওরা খুঁজে পারবে।
এই তো রুল 20, এই রুল 20 দিয়েছি।
Find out from our book. Find out from our book which page.
দেখুন এটা আপনার বই, এটা আপনার বই। 528
এটা ট্র্যাক করবো
আমি দিয়েছি 528
87 is a GI's order.
এই যে
It is a school teacher or non-teaching?
He is a school teacher.
School teacher. Then 21 applies.
Yes, my lord.
সেটা পাতা নিয়ে কি করে দেখবো পাতা
There is where is the schedule?
5
5.
5 ম্যাডাম বইটা দি দুটো পাতা পড়ে
But 21 relates to primary school teacher. 21 is relates to primary teacher. 20 is the word. 20 is applicable. Rule 20. Manner of selection of compulsory appointment. This is and 21 provision for Rule 20 to apply with mutatis mutandi to compulsory appointment of family member of primary teacher.
Rule 5 20 দেখা চলছে
You were a primary school teacher or
I'm a secondary school teacher. I'm a secondary school teacher.
এটা আমাদের এক্সপ্লানেশন ওটাতে একটা পেজ নেই না এটা আমাদের কাছে রিট পিটিশনের নেই দিয়েছি আমার বইটা দিয়েছি রুল 20টা দিয়েছি চ্যাপ্টার 5টা দিয়েছি আমি হাফ করতে না বলেছি আমি যে দাঁড়াচ্ছি স্যারকে আস্তে 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 ঠিক আছে আগে দিন একটা এটা নেই আমার যা বলার এখানে explanation।
Hey, eraser.
চেম্বারটা কামতে বল
সিঙ্গেল
Yes.
My lord, schedule 4, my lord.
5, 4, 5.
Schedule 5, my lord.
4.
5, my lord. About the explanation part, my lord.
এটা আমাদের এক্সপ্লেনেশন
Yes.
Explanation part, my lord. There is, my lord, the expression financial hardship in relation to income of a deceased teacher or non-teaching staff consisting of up to 5 members in his family shall mean an amount of income less than initial gross salary of Group D staff of the state government at the material point of time for computation of income of such family and income of an amount earned by each family member from any other sources than provident fund, gratuity, and 40% of family pension of the first 7 years or upon attainment of 67 years of age of the deceased teacher, had he been alive, whichever is earlier, at the material point of time, shall be taken into account. Then kindly come to page 87 of the DI's order.
These are pictures.
Well, in the rule, there is nowhere stated it is particularly family pension, not disclosed what is the family pension.
No. What is the
I see the DI's order. DI calculated the
87?
87 is the DI's order, and before that,
Yes.
The provision of appointment on compassionate ground of the wards of secondary and higher secondary teachers, etc., have been incorporated by amending the West Bengal Primary School Teachers Recruitment Rule 2001, issued under memo number such and such 2009. At the said rule, there is provision for appointment on compassionate ground when an employee died in harness, leaving a family in extreme financial hardship. The term financial hardship has been also explained in the said rules in relation to income of family of the deceased employee. The Schedule 5 of the West Bengal School Service Commission Rules 2009, high number such and such, reiterates the same criterion of financial hardship. At this case, it appears from the paper submitted, copy of PPO bearing number such and such dated 19 June 2014, submitted on 2nd July 2014 to this office, that the enhanced family pension basic is 13,870 only per month at the material point of time, taking into account admissible dearness relief and other prevailing at the time. Gross pension would be 17,915. Basic pension 13,870 plus relief, DR relief 3,745, medical allowance 300. Income per month as computed in terms of state rules would be 10,749, 60% of family pension of rupees 17,915, which is higher than the gross initial salary of the group staff. That is was 600 such and such at the point of time. So my humble submission, my lord, rule does not specify, rules only clarify the family pension, 40% of family pension. So my lord, kindly come to before page, prior page, that is 86. There is the PPO. Kindly see the PPO. PPO, my lord. In PPO, there is 3 categories of pension. One is service pension, second is family pension, third is, my lord, need family pension. So, my lord, in the A, my lord, service pension, where, my lord, and the third line, my lord, last pay drawn 27,740. It is his last pay drawn. And, my lord, the B, family pension, that is, my lord, 13,870. So, my lord, just 50. 13,870. So, my lord, the calculation should have been done because here, my lord, they stated the family pension. So, my lord, the family pension should be calculated within 13,870.
That is what is calculated.
No, well, they are calculating after adding the dearness allowance,
Has to
relief,
be gross.
everything.
The word used is a gross salary. What
Gross
does it
salary of
mean?
group D staff, not initial gross salary of group D staff. Group D, in case of initial gross salary of group D staff, then, my lord, the DA, other allowances should be included. But here, my lord, not said, my lord, that gross pension
DR
or,
will
my
not be
told.
included. DR will not be included.
But because, my lord, here, my lord,
I'm happy.
no, my lord,
I'm happy with interpretation.
because, my lord,
For very good reasons.
no, because it cannot be, but it cannot be equated with other, because here, the, my lord, here, no, that cannot be, because, my lord, here, my lord, to determine the financial hardship. Here, my lord, not assess the income or a higher income. Anybody may come, my lord, to our higher income group, they are TNS allowance in case of income tax. But here, my lord, the financial stringency of a family, whether she or he needs that. That's why, my lord.
What is the concept of a DA or a DR? to be provided to the employees. Are you aware of the concept?
The DA
Are
and
you, I'm asking you, sir, you are arguing so extensively,
no, I am not extensive. I'm
having
just within rule.
having no idea about the DR or a DA. Why DA is given? Why DR is given? Are you aware?
For the benefit of the
No, that is what I'm saying.
the
You have no
market rate.
idea about the DA, why this concept was introduced, why the government introduced this DNS alliances and DNS reliefs. What was the purpose of doing it? If you do not know the purpose, then you will go on arguing. Only for the purpose of income tax, those would be taken, not for any other purpose. What is the other purpose?
Then rule will possibly say
explanation এটা যাদের কাছে
Yes,
নেই,
বলেন।
এটা আছে।
The family pension includes the DR. If somebody says your salary, whether it includes a DA or it does not include a DA, then one has to understand that what is the purpose of granting DA? Is it something which is outside the purview of the salary, or it is within the four corners of the salary? What for? The word allowances does not mean that it is beyond. That's the basic salary. But whether it will be considered as a component of the salary.
Well, my humble submission is, my lord, since the rule specified to determine the financial hardship, that's why, my lord,
Conservative of way of interpreting.
because why, my lord, the two income have been excluded, PF and gratuity, and, my lord, 40% of family pension. So, my lord,
Two things one has to understand. A payment which is a one-time payment
gratuity.
cannot be said to be a regular income of a family sustained. Provident fund is also one-time payment. Whatever is accumulated in his provident fund, it is paid to the employee on the superannuation. He is not supposed to continue with the provident fund or will keep the provident fund. Again, contribution, no contribution. Gratuity is also one-time payment. That's why they were excluded. That one-time payment does not mean the sustainability will be there for tomorrow. But if the DA is a sustainable one and is continued till the life ends, then will you treat that DA akin to a provident fund and the gratuity? Because it is paid every month and it is increased at every interval of 6 months.
Yes, sir. So that's why,
Yet a recurring one, along with that you are paid.
well, my humble submission was, DA has been excluded. DR,
The different.
well, because what DR is, well, excluded, because, well, the DR is, well, fluctuating. Time to time has been enhanced,
Why is that?
increasing. It is
No,
increasing.
why? That's why it's
That's-
basic concept. This concept
এটা
of
দিলাম আপনাকে
market rate.
I would be beseeching you, you have not read my circular,
ডিভিশন বেঞ্চ জাজমেন্ট আমি দিয়েছি আপনাকে,
which I delivered.
দেখালে তো না দেখালে
It is there.
ঠিক আছে আমার কাছে, জাজকে তো দিতে হবে দুটো কথা।
I traced the origin of this concept of the First World War and the Second World War and how it was done and
It is
why we
convinced.
now normally in a very nutshell I can say
There's no middle then.
that if there is an inflation
Information,
Executive
market rate.
reduction,
inflation
Yes,
in the index which
market
really
rate.
এটার মধ্যে নেই
normal life or doing sustainability with the purpose
সেটা এটাই দেখা।
every month.
দেখালে তো
In order to neutralize that inflation, they will grant it to combat the inflation
যদি নয়
আচ্ছা, আচ্ছা। দেখেছে
per month. Why? It is really an increase of an amount because of the inflation. Tackle it, to neutralize it. It is not something which is a bonanza. No. It is not a bonanza.
In comparison to the market price.
No, this is what is to
Inflation.
make a person sustainable.
Sustainable.
A person is getting 5,000 rupees,
Yes.
whereas the inflation has gone to 70%. He will not be able to survive. So something is to be provided by the government because they are unable to tackle the inflation. So one has to understand that this is really an amount which is given for sustenance of a person to tackle the inflation or the steep rise in the price of a basic food.
Then, my lord, if I
So this is what is to be considered. You are given, if you are given, you say that the DNS alliance, the EA has to be excluded. I don't think so that there is any mandate because that if the correctly it has not been excluded. Correctly it has not been excluded. Has to be included.
well, if then, my lord, then one problem would come, my lord. If the enhanced family pension would be 17,000, then his last pay down would have been 34,000, not 27,000. It is the PPO. I cannot deny the PPO because seeing the PPO, the DI took the decision. Unless the PPO is come.
At that time, and it's, the 37,000, as you see, 27,000 was there. It will also include, or it will, which is because last, that was the pay was 27,000. So it does not include the DR. It's a large job. And this is what is saying that last half of the amount.
এই প্যারা ওদের মেন আপত্তি এটাতে আমি তো শুধু এইখানে যাই 3টে অ্যাড হবে কি হবে না দেখেছে
And my lord, my lord, in my lord, earlier memo number night published on 15th May 1985 with the source of the 2009.
এটা আবার কোনটা হচ্ছে এবার
I would have appreciated your argument on one point. You are not making out the case.
বইটা যাদের কাছে আছে চলে গেলে বলে
এটা তো
এই তো ইনস্ট্রাকশন
kindly one calculation, that is, I am handing up the circular DCRB by DCRB, that is 15th May 1985. In the paragraph 23, kindly see, the process of computation of family pension, kindly see. এটা একটা
2009 রুলস যেভাবে বলেছিলাম সেভাবে করেছি
chapter 70 বার করেছি। That was the method of preparing the family pension. The way how the family pension will be calculated, that is the method. No, I do not challenge the PPO. Well, I do not challenge. Well, PPO, I support this PPO. PPO is supporting to me, my lord. But yes, well, then 13,800 is the my lord, basic. Huh? but there does not input the DA or DR. And my lord, kindly see, my lord, one page, my lord, chapter, my lord, chapter 2, the definition portion. Oh, the pension, oh, this rule, my lord, I am handing over. मतलब एक पेज से प्रश्न है, पेना पेज नहीं है. In chapter 2, my lord, the definition. At the font size, my lord. Definition, oh, my lord, the pension except when the term pension is used in contradistinction to gratuity, pension includes the gratuity.
And come to P. The emoluments
And
means
P, my lord, emoluments means the emoluments which employee is receiving immediately before his retirement and includes basic pay, personal pay, special pay, illness relief. But so that
Yes, yes.
no, 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 before that, no, no. But the rule, my lord, but the rule says, my lord, very specific that but I have twofold prayer, my lord, but I have twofold prayer. One. One thing was Supreme Court last judgment. There were revisited the income. No, that is apparent from the PPO I am telling. It is one that is one I have to take instruction whether he is taking. No, no, that is.
That would have been better way of understanding, but not
No, no, but kindly give me. No, 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 no. Yes, yes, lordship, lordship. Whether he is getting the inputs D or excludes D. If some
regarding 27th.
According to scheme, my lord, that has been provided in a financial hardship. The financial. Yes. Basic. Initial.
Yes, that is about.
In addition to all that, certainly your lordship's view is correct. All other sources of income. So
And exploration file করেছি তো explanation
because when certainly. No, sorry.
But my concept is there was that since it is a determination of financial hardship, that's why, my lord, these are the items has been excluded. These are the even my lord, in the last scheme 2013, the scheme has come. It has more elaborate regarding eligibility criteria regarding compulsory appointment.
Not from the bar.
But in the exception, they have taken that advantage. In the exception, they have taken that advantage. So, my lord, other.
স্যার
7 days, no?
7 days কি করে রিপোর্ট ফাইল করতে বলছে
Report. Well, produce report. Take a instruction.
instruction রিটিন চাইছে এইটা 27,000 টাকা
DPPG. That
Well, a report should be submitted regarding how they have arrived. Yes, well.
the appropriate authority, DPPG, take from the DPPG.
Well, my humble submission is, well, they should have given a report on how they reached this conclusion after taking that 27,000, 13,000, or by taking the.
তাহলে আজ 5 তারিখ তাহলে আপনি যে কদিন থাকবেন না তার বলুন 13 আজ হচ্ছে 5, 6, 7, 8, 13 এক সপ্তাহ থাকবেন আপনি
এই সপ্তাহে করবেন
ফোন করে দিন
Next Thursday. Next Thursday.
Then Wednesday, Malad. Wednesday, Malad.
বুধবারে থাকবে আমার বই আছে একটা। এই আমার ছেঁড়া
I think 8, Malad, I am appearing for the. Well, item 8, I am appearing for the appellant wife. Malad, my lord was pleased to, my lord Justice Tandon was pleased to hear sitting with my lord Justice Madhuresh Prasad this matter for quite some time and some observations were made. That's true, but my lord was pleased to observe that this should be heard before my lord Justice, before this bench. Now that was the order passed on, my lord. My lord, for the purpose of adjudication afresh. That's it. That's it. Your lordship had that determination. No, my lord, I can only say, my lord, the poor wife, my lord, she is suffering. On 15th of July.
My lord, in respect of item number 9, Mr. Kullan Banerjee is appearing, my lord. My lord, he's not in the city. So if this matter can be adjourned for a fortnight, my lord, this matter is continuing for quite a long time. My lord, without his assistance, we will not be able to proceed with.
Whose order?
My lord,
Yes, your lordship.
my lord, sir, but the same bench. Thank you. Same bench.
No.
Oh,
Sitting with Justice Shamant.
Oh, my lord, I'm sorry, my lord. My lord, Justice Tandon, my lord, sitting with Justice Shamant.
The group 2.
It's a group 2 matter. My lord, regarding appointment of my lord, assistant headmaster. Very well, my lord. But can we then, my lord, come? পাঁচের সাথে 12-এর সাথে 19 grateful, extremely grateful.
But in item number 10, Millard, I'm for the appellant. And Millard, Millard, this is cross appeal. Millard, we are aggrieved. Both the parties are aggrieved from the same judgments. But I'm only aggrieved for portions of the judgments and order passed by the learned single judge. But although writ petition has been decided in my favor, writ petition was allowed. Direction was given to reinstate the writ petitioner in the service. But Millard, no timeline has been framed by the learned single judge while passing of the judge.
Does it apply? Appeal lies?
No, Millard, that was my legal advice not to prefer an appeal. So contempt would have been preferred, reasonable time if expired. Now, my client, Millard, somehow he was out of this track after delivering of judgments. He was in very precarious conditions economically. He was totally detached from the lawyers, Latin lawyers. Now, subsequently came later and filed this appeal. Now, Millard, let their appeal. No, Millard, this appeal, my humble submissions fairly, if I say so, my appeal, Millard, I shall not press this appeal. Let their appeal.
Lordship, kindly make it possible, Lordship. I am led by Piyush Chaturvedi, Lordship. He is in court number 26. Lordship, kindly 10 minutes, Lordship.
Item number 12.
My lord, item number 12, my lord, I am for the respondent number 1 writ petition. My lord, Mr. Siddiqui was appearing for the state. Mr. Siddiqui was appearing for the state. The matter was initially fixed on. Then, my lord, can it be not today? I'm grateful.
Item number 13. Item number 14. Item number 15.
Item number 14.
14.
No, Your Lordship, I'm for the respondent.
Appellant is not here. Pass over.
Pass over matter.
Item number 15. Item number 16.
16 to 94. I am for the appellant. Millard, I am led by Mr. Shubhi Shanal. Millard, may it be passed over.
My lord, so for 17 is concerned, I am appearing on behalf of the state.
Yes.
All the matters you are there.
No, my lord, only one.
You are appearing for the other respondents. All are state. All the respondents are state.
Yes. No, DPSC, my lord.
DPSC.
There is a other
District
state.
Primary School Council,
District
Hooghly is
Primary
also.
Council, my lord, it is an independent body. I am not appearing.
Different primary school council or one?
Only one.
Only one.
All these matters, I'm talking
Yes,
about
my lord,
all the matters.
Maharaj,
All the
Mr.
matters
Bishwabrata Basu Mullik appearing on behalf of the district.
Now, which one should we take?
But I think Ovijit Sadhu Khan. Malad FMA 244-2021.
Serial number
85.
85.
85.
My lord.
People.
Paper.
Is it Mohammed Khan?
Impugned judgment at page 17, one sub.
Assistant হচ্ছে যেটা করেছিল assistant page 8.
Yeah. 20 or 72. Yeah. Stated.
দিয়ে দেবেন আমার কাছে আছে এখানেও আছে
Maybe. 94, item number 94. A senior repair profession. Online. Mr. Juma Chakravarti.
Please submit for all the matter. For all the
Want to consider? No, point appears to be very simple. There are 2 points which, in my which my consideration or in my view, after reading the judgment, I have not gone into the facts, but the facts disclosed in the judgment, whether there is a scope for but it is not whether of the card rather this is not a PC box is done.
Well, my humble submission, your lordship has rightly taken the first point. Second point, I am not really on. And I believe, my lord, probably, I don't know, with the lawyers and the honorable judges always somehow keeping in our forehead the earlier matters or not. Because I am not trying to your lordship's prejudice your lordship's mind. There is a judgment of your lordship's single bench. Whether the panel for trained and untrained judgment can be prepared or not. I don't know for that reason stuck. Yeah. Only one thing I tell you, lordships. Admittedly, our total marks are higher than the trained candidates. Admitted. No, no, not even. Not even. Malad, I take you. Malad, that's Malad. Malad, kindly see page 174A. 174A.
174 नहीं थे 174 पेज को था
Exactly.
ज्यादा है ना इतने पेपर
Exactly, that's right. Right.
But he is not trained, has obtained higher marks than you. How can you say?
No, I tell you losses here. First point, as your losses pointed out, there cannot be two panels. There cannot be two panel. First. Second of, admittedly, 42.9778 is much higher marks than the trained candidate. Third point, your losses as
untrained.
Yes,
yes.
Well, that's the illegality. Suppose I tell you losses, they
Have you challenged the ultra vires of the state?
Non-trained.
There cannot non-trained. But your lordships, my case is that if you gave a appointment to a trained candidate who has secured letter,
Say that you are entitled for 20 marks on the basis of this training certificate.
I'm not saying that.
Then the issue would have been different. But it's a point in the wrong one at page 24, paragraph 24 of the judgment.
Well, factually not wrong, but legally this is wrong.
Like you say,
I tell you losses, rules do not permit two panels, trained and untrained.
but suppose then the panel reporting this situation the persons which they
Trained.
obtain the marks reporting marks
I will come up.
on an ascending or descending order.
I will come up.
It shows that certain candidate but higher marks.
So they will remain, I will come up. Because our trained candidates will go. I tell you losses why.
The question is, then again, trained candidate will go. Candidates, they say that the trained category, they obtain the higher marks.
No.
And then, what are the marks obtained by them?
Well, last trained candidate got 38.0772. Last trained candidate.
Who are in the unreserved category.
Unreserved category.
960 candidates were impaneled.
Exactly.
Then first, the marks obtained by the first empaneled category is 5.09.
Correct.
The last one was 48.87. Come under this bracket, you are under the not paid.
Trained your losses, may I take 174A, councillors in the judgment. Judgment I take. Judgment ওটা বলেনি কিন্তু বলেনি judgment didn't discuss it. Page 174, capital A. But only one thing, I stand corrected. One reference is there. If your lordships kindly come to page 30 of the judgment. Running page 30. Page 30, paragraph 39. Accordingly, I cannot lose sight of the fact that the same selection. Exactly. Last campaign. Exactly. Now your lordships, kindly have a look at 174 capital. Kindly page 174 capital A. Details of this has been disclosed by the council. Details of lowest marks of the last panel candidate are as follows. Malad, we are concerned with Bengali media. Train 38.0772. Unreserved 47.7. Malad, we have got 42. Calls are following. Now I will take your losses to the rules.
Leading us.
Malad, page. It starts from page 302.
Come here.
Now I take your lordships to the relevant portions only. 302. 304, your losses straightway come to 304. Rule 6. My lord, 1. No person shall be appointed by the council.
304. আমার বইটা কোথায় গেল?
My lord, 304, rule 6. No person shall be appointed by the council as a teacher unless a normal citizen of India completed age and C possesses the minimum educational qualification as mentioned in sub rule 2. Well, kindly see what the rule 2 says, sub rule 2. Educational qualification for the post of a teacher shall be A, full final, Madhyamik pass under the West Bengal Board of Secondary Education or equivalent, or B, erstwhile secondary pass under the West Bengal Board of Secondary. Nothing required, my lord. 3. Training qualification may not be compulsory for appointment on compassionate ground. Leave it. Now your lordships. 5. No extra marks shall be given for any academic higher qualification at the time of selection of a teacher. Then the proviso is important. A trained candidate shall be given extra marks in the manner prescribed under clause D of sub rule 2 of rule 9. Pause here for a moment. I just tell you also one fact. They have been given training marks. But even then I have got 42, the last 38. Then your loss is 6. Priority and preference will be given to candidates having requisitioning training from a recognized institution, provided candidates will be recruited on merit basis if 10 candidates is not available. So, my lord, priority and preference will be given. Now, my point, your lordships, after let me place the rule 9, then I will, my lord, my argument I will advance. My lord, kindly look, page 306. Well, 306 says how the procedure, selection procedure, your losses will find Roman 2, sub rule 2, bites.
It will be given for 100 marks, out of which 90 marks have been
Exactly.
5 marks for the
Exactly.
academic qualification, marks for the training, and 2 marks for the
work.
Then 10 marks remaining.
And then written. Now your losses kindly come to the next page. I am on rule sub rule 8. After the process as laid down in sub rule 7, that means total marks after being added is completed. The selection committee shall at first prepare a panel of candidates under the general category with all the general scheduled caste, scheduled type, other backward classes candidates and shall be arranged according to their merit. But where is the trained and untrained panel? Then your lordship, this is because the This is because the number of scheduled caste, scheduled tribes, and other backward class candidates qualifying on merit for appointment to any unreserved vacancy in a service or post in any establishment to be filled up by direct recruitment shall not be deducted from the quota reserved in service or post for such candidate. Thereafter, the selection committee shall prepare separate panels for scheduled caste, scheduled tribes, and other backward classes candidates in the respective category as per statutory reservation rules, all that. But my submission is that on merit basis.
Higher marks on merit. For the posts which are that will not be listed, that should not be. They will be
General.
the wrong.
Indra Sahni.
Indra Sahni, this is the law.
Sahni.
Constitution is difficult.
No, I'm asking for that. I'm not also complaining that. All that I'm complaining, rule does not conceive.
In our
No, that is being followed.
how has to be done. Then the merit unreserved category posts are earmarked candidates scored higher marks of merit. Then segregation from the rest could be done. So now the
All reserved vacancies, category wise.
This is how
Now, what they have done, I am on secured higher marks.
the court.
Court immediately. Within the time, within the validity of the panel. This was court directed to consider. Because one thing I can tell you, factually he can remember everything. He doesn't forget. Actually, he remembers everything. He doesn't forget any of the facts, Mala. That's true. This is second round. First round, court directed to consider. They rejected by saying that, look, you are below the last candidate of the untrained. Our point is that you cannot.
I got your point. Your contention is that first where a panel votes segregated. Then whoever secured the higher marks under the unreserved category, maximum number of the up from there, and then you can go and segregate it. There is no point of segregating the panel at the initial stage and then making a different cutoff marks for each category.
Categories which doesn't untrained, trained.
This is what you're.
And the second point I tell you, lordships, preference. Probably that will. As your lordship knows, preference Supreme Court has been defined. When all the things are equal, then preference can be given. Things are not equal. Things are not equal, my lord, because I am on higher side on marks. You cannot give preference to a trained candidate. Law says preference. If the thing, suppose your law says I got 30, trained 30, then trained candidate can be preferred. But I got 42, trained 38, trained cannot be preferred. I beg your lordship. Exactly, my lord. I showed you lordship. Your lordship said that.
ওকে একটা দিয়ে দে বাবা ওকে একটা দিয়ে দেন
আমার কাছে আছে H2 last two lines, then onwards. Well, factually, he lost. Interpretation of the rules, that's your lordships. That's only this. And I'm citing one judgment, your lordship. What's the preference meaning? কোন জাজমেন্টটা বলো? 2006. হ্যাঁ। বলো এটা বলো। 2006, volume 6 SCC, page 474. ঠিক আছে?
4 SSC.
Volume?
4 SSC page.
Reference me.
No, page.
Volume?
2006, 6 SCC 474.
Preference.
ফ্রন্ট পেজটা একটা ছবি তুলে নিই।
বাড়ি থেকে ডাউনলোড করে নিন। বাড়ি থেকে ডাউনলোড করে নিন। ক্যামেরাটা বাদ করো।
This is reported in 2006, 6 SCC, page 474, paragraph 16, 19, 19 and 20. Well, I think and 20. So the 16 makes it amply clear that was the interpretation of the terms preference. This court has consistently held that when selection is made on the basis of merit, assessed to the competitive examination and interview, preference to additional qualification would mean other things being qualitatively and quantitatively equal, those having additional qualification will be preferred. It does not mean an en bloc preference irrespective of inter-se merit and suitability. What they have done exactly, en bloc preference, trained. Paragraph 19 then.
Wait for it. 2006 volume 4 SSC নিয়েছে 474 কি কপি আনবে চেক করো
This is the point, analysis. This is the point. And the other judgment, I tell your lordships, that's at 2017.
2017, 16 SCC.
2017, 16 SCC, page 346, paragraph 11. Page 346. Just
2017? 2017?
16 SCC 346
Paragraph? Paragraph?
346.
Paragraph about 346 page.
Oh, paragraph.
11.
11.
11. 346. Para 11. Reliance has been placed by the learned counsel appearing for the railways trained apprentice on the judgment of the court passed in such and such. In para 12 of the judgment, it has been held that all other things being equal, the trained apprentice should be given preference upon direct apprentice. This judgment does not help the appellants at all. What has been held is that if the non-railway trained apprentice is equal to the railway's trained apprentice on merit, then preference can be given to the railway's trained apprentice. The word preference does not mean that the railway's trained apprentice will have an exclusive right to the exclusion of all others to be considered for appointment. This is our case, Your Lordships. My last point, Your Lordships, I do not want to take away any other appointment. Since I am on the higher side, please, all the petitioners who are now before Your Lordships after a long time, they are fighting this battle, let them be appointed. They have hardly anything else. This is my submissions.
Kindly see, according to the finding of the learned single judge, that they obtain a training from a training institute not recognized by the NCT. Kindly see that NCT Act came into force. Right. My lord.
This is different. It's not saying that these are what we have done is done is that separate
Untrained candidates.
there we are going seeing that what we are saying is that the bracket of merit first. Whoever is secured the iron marks, let him be appointed. He has no remark. And then you put a segregation. Your notification does not say segregation. It says the preference has to be given to
Candidates.
or non-trained
Candidate.
contention. So what is the meaning of the word preference? Does it mean a separate panel to be prepared or something else? We argue with these two judgments that it is something else, not the different panel. That is what is argued.
Yes.
To that, what is your reaction? Now, you have prepared, the learned judge has said that since the preference has to be given to a trained candidate, so if you have prepared a two separate panel, that is quite justified. This, he says, joinder issue. So, this finding is perverse, finding is contrary to the judgment. Supreme Court. If I take you to that finding of the learned judge, he has discarded simply on this ground.
Kindly see, if
Yes, paragraph 30, the judge.
yes.
Come to page 27.
Yes, madam. I am unable to accept the contents of the petitioner. The interim order dated 23rd September 2000 passed by the learned single judge in case of Gopal Saha required the respondent to conduct the selection process in 2006 as per unamended rules. Yes. This means the recruitment process was to be completed as per provisions of the West Bengal Primary Teacher Recruitment Rules 2001, Rule 6, after which was inserted by amendment dated 16th December 2005, provided the priority and preference provides that priority and preference should be given to the candidates having requisite training from a recognized institute, provided the candidates should be recruited on merit basis. If trained candidates are not available, hence Rule 2001 rules clearly envisages the two categories of candidates. That yes.
At this finding of the second judgment of the Supreme
Paragraph 38. Kindly see paragraph 38 for a moment.
That's the only one line.
Yes.
Not arguing 20 marks would be awarded.
But the another point, kindly consider. No, if enters, yes, but kindly the learned single judge has held that all the candidates has not been made parties so far as selection is concerned, challenging the entire selection process.
Those are made particles that
But said their appointment would not be disturbed, supervisory post would be created for them. Yes, can you see that?
single judge has. Single judge has started.
30 table for me there. 38, can you see for a moment?
39. I am
No, 38, page 29 for a moment. The Commissioner of School Education, West Bengal, be responded to also notice the office memorandum
challenging
that
that he has not obtained the requisite marks in the untrained category.
but can you see there? Just give me a minute. Petitioner belongs to the general category and has no training qualification. He has obtained 42.9778 marks, which is below the cutoff marks of empaneled general candidate, of non-trained candidate. Non-trained.
Because in a trained category, to come to this, what was the mark?
Yes.
174A.
Something.
174 capital A.
Last candidate 48.89.
Oh, paragraph.
48.89.
39 year losses, judge. Page 30, judge.
The last candidate 48.8944.
The trained candidate which you have appointed after awarding 20 marks. Last one was the trained candidate, they got 38.077. Come to page 33, paragraph 39.
I cannot lose sight of the fact that the same selection process was challenged in Ananya Banerjee versus State of West Bengal. The same argument was advanced by the petitioner that though a trained candidate obtained 38.0072 marks empaneled and given appointment, the petitioner was not appointed even after obtaining 47.5 marks. The learned judge by judgment and order dated 19 December 2012 upheld the selection process. The learned single judge held the panel should be prepared in respect of selected candidate irrespective of their category in the first place. Thereafter, category-wise panel should be prepared depending on whether candidate is trained or not. Then, the allotment of 22 marks to the 10 candidate was also upheld by the learned judge on inter.
I think you have not applied. You are not applying.
No, my friend is.
You are not applying. His grievance is that he has obtained 42 point something.
Yeah.
Whereas the trained candidates, after allotment of 22 marks, obtained 38 point something. How can you judge a merit? Why you have given them an appointment? Why not to the candidates who secured more than 38 point something?
Exactly.
But I'm for another angle. But if the said selection process is found to be correct by a learned single judge of the Supreme Court, but that has been quoted in the order.
Quoted. The quoted was that you will have to prepare.
The panel should be prepared in respect of single candidate irrespective of their category. First phase.
Done. You have not done. From the very first, you have categorized it.
As being for a moment, I have committed a wrong. So for interpretation.
So what is blunder?
But then the entire selection process has to be set aside by your lordship.
Why it will go?
Then all the.
It has to be done in this manner, and whoever, that is what he says, whoever has been appointed, do not upset. But include somebody else.
Now, the kindly see 2009 selection process or 2006 advertisement, 2009 selection process. What we are in 2024. In the meantime, vacancy has been occurred. Can I fill up the vacancy? Because of Right to Education Act came into force on 1st April 2010. And according to that, he must be a TET qualified and must have a 50% marks. Can I appoint today? Assuming for a moment that the judgment is wrong for a moment. Entire selection process has to be set aside. Right to Education Act came into force 1st April 2010. Then there is a 25th August 2010, there is a notification issued by the Central Government.
Whatever the wrong which was committed gets validated by virtue of a subsequent enactment.
Yes.
You have to hold
No, what I can't.
one judgment of any court which says that the wrong which is technically illegal.
No, what I
is validated by a subsequent.
No, if some law has been changed, court can, I think the court should take note of that.
There is justice which has to be nipped in the bud with the eye.
No, I'm not saying that. No, I'm not saying that. Kindly see.
37
Kindly see for a moment, paragraph 37, just give me 1 second, indulgence. It is not.
37.
Ananya Banerjee. Well, I think the single bench judgment is Ananya Banerjee. Single bench.
Kindly see the, kindly give me indulgence, paragraph 37. It is page 28. It is not disputed that the total marks obtained by the petitioner 42.9978. It is also not disputed the Bengali medium schools under unreserved category 906. Non-trained.
Forget that.
Non-trained. Candidates were empaneled. The first empaneled candidate secured 65.9038 marks and the last empaneled candidate 48 marks. The respondent number 4.
Consideration did not come. But how can a person who secured 38 point something marks is still favored with the appointment? Whereas a candidate of 48 below, just below 48, did not. Forget about his age, got 40. Not coming, but somebody who is there above it, why not? One can flag an issue.
First candidate 65.9038 and the last candidate
48.
48.
But you have given an appointment to a candidate who has secured 38. If the last candidate was 48 on merit, then how 38 got an appointment?
Kindly see that. The respondent number 4, being the chairman of the Ugdi DPSC, his office memorandum dated 25th July has discussed the entire issue in details. Thus, the marks reserved category are below the cut-off marks of the unreserved category. In the unreserved category, the cut-off marks in the scheduled list 48.38994.161 posts were converted into exempted category, unreserved from not unreserved category.
When
vacancies fill up.
What is your rule?
Rule of 2001.
Sir, what it says.
In 2005, amendment was made.
Sir, what it says after amendment, what is to be done? The rule says that after the examination, you will prepare one list on the basis of the merit without any category wise. If the unreserved category the posts are 960, then you fill up 960 on the basis of a merit first.
Merit first.
Then, after filling up that, your rule also says that you do not want to eat up the vacancies earmarked for those reserved category. If the candidate belonging to any of such reserved category, if he comes within the zone of merit, then he will be put into a general category on the basis of the merit, so that the total number of vacancies of the category-wise vacancy is not disturbed.
Yes.
And then you prepare the panel in a category-wise manner. After exhausting those, and do you have earmarked 960 posts for unreserved category?
Yes. Then we
so fill up 960 on the basis of merit.
Yes. But kindly allow.
Fill up the 960 by segregating into two parts.
Kindly allow me to.
The trained, another is an untrained. How can you do?
Kindly allow me to place this. The marks obtained the reserved category are below the cut-off marks of the unreserved category. In the unreserved category, the cut-off marks in the selected candidate 48.38.161 posts were converted from exempted category to unreserved candidate, normal reserved category, and a candidate belonging to an unreserved category cannot and could not be included in the said reserved posts, which are exclusively reserved for general candidate. In terms of Rule 9(8) of the West Bengal School Recruitment Rules 2001, the record shows the 11 candidates were impelled as a trained candidate in terms of Rule 6, Sub-Rule 6 of Rule 6 of Recruitment Rules 2001, which was enforced at the time of notifying the vacancy in 2006. But the vacant rules at the time of notification of 2006. The general candidate, general trained candidates securing 38.77 marks was included in the panel on the basis of rules, Sub-Rule 6 of the West Bengal Primary Recruitment Rules 2000, which was inserted by notification dated 16 December 2005. Sub-Rule 6 West Bengal Primary Recruitment Rules 2000 is independent, and any other rules to the recruitment in terms of the said rule is a trained candidate has to be appointed first, and if no trained candidates are available, then only on non-trained candidates can be given appointment, following the procedure Rule 9 of the Recruitment Rules 2001. The petitioner in this petition is a general category candidate, non-trained candidate. He has obtained 0.66 marks in the written examination and securing petitioner. For a kindly see the obtained only 0.600 marks. In his written examination and academic score of the petitioner is 36.9778. Thus, total marks of the petitioner was 42.9778, which is below the cutoff marks of the least employed general category candidate and non-trained candidate. Therefore, in view of the facts stated above, the claim of the petitioner is not sustainable and the same is rejected. But I kindly consider one thing. Today, my lord, if set aside issue a mandamus directing the government or the primary council to appoint the appellant, whether entire selection process would be set aside, only the petitioner. If the vacancy has been filled up, then my lord, we shall have to create a supernumerary post. How it could be done? But I kindly consider this. If there is an interim order by this honorable court, I could have think otherwise. Assuming for a moment, your lordship rejecting my all contentions and allowing the appeal, then your lordship is to pass an order directing the state government to approve their appointment. But if the post has been filled up, first one, then today we shall have to appoint a candidate who has got the requisite qualification or 2006 recruitment rules. 2006 recruitment rules is no more in force today. Kindly take it up tomorrow. And kindly see, consider whether in the absence of necessary and proper parties, namely the selected candidates, entire panel has to be recasted because of the No, entire panel has to be recasted. Yes. 2014-16 SSC, page 187, paragraph 4 to 13. Mud. No, but I shall have to give answer to the questions raised by your lordship. No, I shall have to give them. Kindly consider that. If today Malad accepts contention of Mr. Channel, then we shall have to give appointment to them. Then panel has to be recasted. When panel has to be recasted, then what is the effect of it? All the candidates must be before the court. Not only, and 11 candidates, they are not challenging. Since you have appointed 11 candidates, let them be there, but we should be appointed. We should be appointed from where? From the post available and according to the qualifications. Kindly see 2014-16 SSC, page 187, paragraph 4 to 13. Paragraph 4 to 13.
Page কত বললে দাদা?
এক সেকেন্ড 2014-16 SSC 187 Ranjan Kumar and other versus State of Bihar. 4 to 13. On perusal of the orders imputed, we find that only 40% were made respondent before the High Court, only few appointees filed pre-application for intervention. It settled that no adverse order can be passed against a person who have not made parties to the litigation. In this context, we may refer to the profit of authority of Prabodh Verma versus State of EP, wherein 3 judges bench was dealing with the constitutional validity of Uttar Pradesh ordinance, which had been struck down by the division bench of Allahabad High Court on the ground of provisions therein violated by Article 14 and 16(1) of the Constitution. This context, a question arose whether the termination of service of the appellant, the petitioner there is secondary school teacher and intermediate college lecturers following upon a High Court judgment was valid without making the appointees as a party. The learned judge observed that the petition filed by Sangha suffered from two serious, though not incurable defects. The core defect was that an ungender of necessary party. For the respondent, Sangha's petition for the state of Uttar Pradesh and his officers concerned, and those who are initially concerned, namely the reserved school teachers, who are not made parties, not even by joining some of them in the representative capacity, considering their under number as too large, all of them to be joined individually respondent. Thereafter, court, Prabodh Chandra, the matter therefore come to be decided in their absence. If High Court not to be decided, it petition under Article 26 of the Constitution without a person who validly affected by such judgment being forced as a respondent, at least by some of them being forced as a respondents in the representative capacity. If their number of is too large, therefore the Allahabad High Court ought not to have proceeded to hear and dispose of the time to work. একটা 15 বেজে গেছে। High Court not to have proceeded to hear and dispose of some petitions without insisting upon the reserved pool teachers being made respondents to that petition, or at least some of them being made respondents in the representative capacity. Had the petitioner refused to do so, ought to have dismissed that petition for non-referral. In the case at hand, neither any rule or regulation challenge. In fact, we have apprised that at the time of selection and appointment, there is no rule or regulation. A procedure has to be adopted by the administrative instruction. That apart, not a large body of the appointees, but only 182 appointees. Quite apart, the persons who are impeded were not treated to the capacity. Then Indushekhar was considered. Then Malad Rosmini Mishra was considered. Then Mala Public Service was Mamata, paragraph 9 was considered. Then all the judgment, then paragraph 12, despite indivisible effort, we are persuaded to accept the appointment. For once the respondents are promoted, then we do not. Paragraph 13. View of the aforesaid demolition law, we are disposed of to think that such a when all the appointees are not impeded, this petition was defective and hence no relief to be granted to the petitioner. And give me 1 day time. No, Baba, I shall have to.
I do not reach. Lost this order for activity. Addition. We are coming back. No, today, just ask Mr. Shanal, his forgotten record to supply the entire the paper because it was not supplied to everybody. No, my lord. No. Only ballot. That have you not been served with the no, so that. To have the basis. Ballot only may I take. The thing will enter into the merit. Ballot. Everything is pretty nicely. Yes, absolutely. And my lord has on the basis of those findings. Ballot, may I point is pure. Point is pure. Question of law. May I take one? May I take one in there? May I take ballot only for this team. Kindly allow so that I can. My lord, my lord's observation, my lord, I have no observation. No, ma'am. No observation. No. My lord cannot. My lord, only thing, my lord, kindly give me that. My lord, only 1 day accommodation. My lord, I can add, my lord, I have followed. Whatever queries which I have fallen for my lord, I have
I have taken note of. So, my lord, kindly give me one day. This is the opportunity for, my lord, for before appearing before my lord. I do not want to miss that.
This is more
No, this is, I do not want to miss that opportunity. I want to, my lord, make humble submission. My lord, I am begging one day, my lord, no, this is the, my lord, I am learning. Because anything I left, my lord, kindly give one. My lord, kindly.
Tomorrow as a first matter.
Tomorrow, my lord, yeah. My lord, day after one, because Mr.
Give them.
Yes, I want a copy of
the improved order.
Input order, my lord. Only thing, my lord,
That.
my lord, not tomorrow, day after tomorrow. Because, my lord, I want to distinguish this.
Then come at 2.
No. All right, my lord. At tomorrow.
Yes, first matter.
My lord, in the next matter, would your lordship take it up day after tomorrow because I have part
Item number 95.
বলো 10 বলো 10 বলতে বলছি আসলে নেই
95, my lord. I'm for the appellant, my lord. I'm for and
দশে বলেছি
day after tomorrow.
My lord, I am appearing for the college, my lord. My lord, not this week, my lord. This week, my lord, then my lord, not this week, my lord. My lord, I will going for treatment, my lord, for a week.
My lord, will it be my lord's pleasure to take up the Passover item number 10, both sides?
Not this week.
For the day, my lord?
I do not know. We can come back.
As a lord.
96 and 97.
My application for modification, my lord. Well, I'm the writ petitioner, respondent in the appeal preferred by the university, and the cross objectionist. I rather was, my lord, these were disposed of, appeal and the cross objection was, this is my every bit of. Serve upon the learned advocate appearing on behalf of the university and the concerned authorities of the university itself, my lord. Page 60 is the order passed by your lordships. No, no, absolutely. Madam, may I? Now, my lord, at the time of disposal of the appeal, my lord kindly comes to page 41. I had twofold prayer in the original lead application. Now, one was set aside the orders and the orders on review passed by the university, and prayer B, page 42, writ in the nature of mandamus by directing the and commanding the respondents to allow the petitioner to resume her duty as the assistant professor of the said university by treating the period of absence of a petitioner as leave without pay but with continuity of service. Now, my lord, at the time of hearing, we pointed this out. My lord was desirous of granting this relief. This did not go into the order passed by your lordship. I mentioned the matter before your lordship for correction. My lord deprecated my way of getting the order by way of on oral prayer. So I filed this application is only with regard to allowing me to continuity with service of my service, my lord. And I've already joined. Rather, I've been allowed to join, my lord. I have prayed for continuity of service. They have kept themselves mum with regard to that. Only that much, my lord. Mr. Chakraborty is appearing.
That's pretty big to appear on. My lord, this was my appeal, which was dismissed by this honorable court, and my lord, affirming the order of the honorable reed court and directed her to join in the university. She has filed a cross objection that was rejected by this honorable court.
Two grounds, my lord: creation of supernumerary post and back wages. Both of them were rejected by the common order, my lord. I have not preferred anything against that order.
But in prayer, they have categorically stated without any back wages, only to be treated as leave without, my lord, any salary. And innumerable application has been filed by her, my lord, before the authority. Do not require to pay any salary and all these things. That was the prayer. And my lord, the cross objection, the separate prayer, lordship was kind enough to reject it. I am referring, my lord, page 58.
I am not on back wages, my lord.
Lordship.
The thing is that since he has also played for
Lordship.
the continuity in her service,
Lordship.
that continuity has to be considered.
My lord.
Well, I may be allowed, my lord, to read, my lord, the relevant portion of the Honorable Reed Court's judgment. But page 58 may kindly be looked into, my lord. The respondent at the bottom, my lord. The respondent authorities are directed to reinstate the service of the petitioner within 4 weeks from the date of receipt of the copy of this order without any back wages. However, the authorities are at liberty to initiate appropriate inquiry against the petitioner as provided under the law if the authority intending to do so. So that was the mandate of the Honorable Reed Court. My lord, being aggrieved, if refer appeal, lordship was kind enough to reject it and my lord dismiss the same. And here, my lord, rejecting, my lord, our contention and affirming the order of Honorable Reed Courts, page 65 may kindly be looked into. Page 65. Lordship, our humble submission in the event fresh cause of action arise, my lord, he sees that is at a liberty, my lord, to come before this honorable court. At the same time, there was a liberty to initiate proceedings against her. My lord, time is yet to go.
Fresh cause of action.
My lord, in this matter, my lord, he is seeking, my lord, modification.
File a cross objection. That your continuity of
Yes, my lord, deeply obliged.
The original writ application was there, my lord. The prayer was my lord. It fell from your lordships.
not be done.
Deeply obliged, my lord.
Fell from your lordships, my lord. That prayer would be granted at the final relief, my lord. That was not go. My lord, well, I don't want to refer to the YouTube recordings, my lord. It was there, my lord.
It cannot be.
May I submit one thing,
Verbal
my lord?
prayer,
Since,
lordship,
may I
but there
submit?
on verbal prayer praying something, my lord, lordship was kind enough to refer one Supreme
May I
Court Shahayika Shambhav, my lord, in all probability judgment cannot be done. Come with application. This is the application.
May I
Nothing more,
submit?
nothing less.
The inquiry, even rather, there was no inquiry by the university at the time of my termination. There was no merit. They did not go. It was not on merit. My termination was, this was set aside.
Set aside, everything has been done. What more?
I have joined, but the continuity of service, my lord, since the reinstatement is there, my lord,
We can't say now.
it fell from.
Continuity has to be done. We can't say now. They have to think.
I have already preferred an application. Let them consider that and pass an order giving me a fresh cause of action to come before this honorable court. That application is before your lordship. My lord, kindly sees page 67 for once.
I file.
That is my request for reinstatement. Second paragraph. With effect from 1st of July 2013. Let them consider that application and pass a reason order if they so desire, my lord. Now, only before your lordship, since it is fell from your lordship. Otherwise, I would not have bothered this honorable court, my lord.
Observe the course of the interaction does not mean that.
No, it was not observed, my lord. We prayed for that. My lord, let there be a direction to consider this with regard to continuity of service. I'll be remediless, my lord.
You have made them wise.
My lord.
You have made them wise by this application.
I did not intend.
What they could not ponder upon, you have invited him to so.
I understand multiply. I could have had better grounds, my lord. I understand, but the clarification could not have come better from any other scope, my lord. Only pray, my lord, that let them consider and pass an order with regard to that, my lord. I'll be having a cause of action to come before the otherwise, my lord, there will be ambiguity with regard to this. If my lord don't consider.
Reinstatement means what?
My lord?
What is the meaning of the word reinstatement? Reinstatement means
as if it never happened, termination never happened.
That's all.
But then my lord kindly clarifies. Only because the university is not acknowledging that. I have their letter.
So that could have been done in another forum. That cannot be done in this way.
Since the order was passed by your lordship,
that
modification is never intended in this way.
I had no other.
You have the other remedies, but it can't be done in this.
It's a rather heat application, my lord. It will be. I'm only.
Supreme Court in innumerable judgment has cautioned it.
Only praying for, since it fell from your lordship. Otherwise, I would not have come before your lordship, man.
Judgment and they say what is the scope of modification.
I understand my scope would be very limited then. No, only praying. Let them consider this aspect and pass a order, my lord. Reinstatement.
Any jurisdiction cannot be passed in the guise of a modification.
What should say that granting fee?
Even judgment is against.
And my lord, reinstatement means continuity.
Jurisdiction, the court is passing a fresh direction. I have deprecated.
It's the motive.
Deprecated.
It will be merged with the original order, my lord.
My judgment is against.
Since the single bench's judgment is merged with the division bench, if there is any direction, this will be a merging with my lord's order as well.
One has to understand.
Without any rights, without any prejudice to the rights and contentions of the petitioner.
One law that in exercise of modification, the court can pass a fresh direction.
What a fresh direction, my lord.
Fresh direction.
I'm reinstated.
Sit down. The court has not considered anything. The court has said reinstatement.
My lord.
Now you wanted it by virtue of a modification application, you wanted that your case should be considered since the subsequent request has been made.
No, my lord, not a subsequent request. My original writ application involved my prayer, my lord.
So then,
the writ application was before your lordship.
Then also the modification cannot come. If there is an error apparent on the face of the record, then
review.
You cannot achieve a review by virtue of a modification. There are at least 4 Supreme Court judgment against you.
Whether this will be treated as an error apparent on the face of the record.
They wanted to say?
No, I did not. This could not have fallen without any prejudice to the rights and contentions of the parties, my lord.
Why you
any observation made herein, my lord, may
say that no modification cannot come in.
May be granted liberty to approach appropriate remedies, my lord.
Grant you. Supreme Court has cautioned. Not only in a modification jurisdiction, but also the contempt jurisdiction. Supreme Court has said you can't.
But Supreme Court has also said reinstatement categorically impliedly means that a continuity of service is there. My lord, kindly grants me a 1 day's accommodation. I'll show those judgments before your lordship.
And then I will also bring those line of judgment that what you really intend to come. I will also bring.
This has to be, if my lord so directs, this has to be goes through review.
No, we have not.
No, my lord. No, my lord. I apologize. I tender my apologies, my lord.
You will say that by an observation of the page.
I'm not praying for such an observation. I was not praying for it.
Anything, we are not saying anything.
No, I'm not praying for such an observation. I was only praying.
You have not made any order.
And can you keep it on Thursday? May I come back with judgment?
Please say that in a modification, you really wanted to point out the error. That's all.
Very well, my lord. Very well. Very well. Let that order be passed, my lord. The apparent error. Modification. My lord has directed. My lord, it fell from your lordship just now. My lord is dismissing the application from a modification.
So line of judgments. Supreme Court has deprecated that in the guise of a clarification or modification, one cannot achieve review. So we will say, no, this cannot come.
Under the purview?
Modification. Yes, ma'am.
As regard. My lord kindly grants me 1 day's accommodation. I'll come if I can at all satisfy your lordship on the next occasion. If not, my lord, I shall take whatever falls from your lordship, my lord. I'm grateful, my lord. Day after tomorrow, my lord. Tomorrow, my lord. Tomorrow. Tomorrow. I'm grateful, my lord. I'm grateful.
At number 98 and 99.
My lord, 98, my lord, I beg to humbly, my lord, pray for
1 week accommodation, my lord. কেন রোজই তো হচ্ছে এভরি টাইম my lord, Mr. Ganguly is leading me, my lord, and my lord,
Court has fabricated an adjournment on the ground of a sin. Then what is the utility of engaging it here? What is the role of the advocate and the court?
it requires, my lord, some time, my lord, for
an
preparation.
advocate and record.
Some preparation
Sorry,
time, my lord,
what-
is
why you
required.
did not prepare? This matter is pending, listed for a law.
My lord,
This matter is there. Sorry, now I have to be very strict. When I find that the council is only engaged for the purpose of an adjournment, I am the last person now. I will not grant. This is not the job of the advocate and record or the junior. He should have.
my lord,
Supreme Court has deprecated that on the ground of senior no adjournment.
my lord, very well, my lord, next time, my lord.
Still, we are still granted. No, this is the fourth time you are asking. Every day when you come, you ask for an adjournment. I have not seen you arguing a single matter of your own till now.
Next time, my lord, I will argue, my lord.
I will give you, but you have to argue the matter tomorrow.
My lord,
Give an undertaking that you will argue a matter. We will give you a time to prepare. But you'll have to give an undertaking that you will argue, not senior.
I will argue, my lord, on Friday, my lord.
Give an undertaking.
Yes, my lord. If he does not come, my lord, then
Give him. Put your signature.
if he does not appear, my lord, I will argue.
No, you have to argue.
Yes. On Friday, my lord, I will
Argue.
on Friday, my lord.
Yes. Give him. That he will write that he will argue, not his senior, on Friday.
No, with the learned senior, my lord. I will argue.
Here, adjourning on your ground that you want to prepare.
My lord,
We have not granted a time for the senior. To argue, we are giving you a time.
Yes, I will. If he does not come, my lord, I will.
Let him argue. Time they want to prepare, definitely we will agree. Giving you.
My lord, if he does not come, my lord, I will argue on
You
Friday.
have to argue.
Yes, my lord, I will argue, my lord, on Friday.
So argue. On the prayer of the appellant, let this matter be distributed.
Yeah. Item number 100.
Your Lordship,
Can to someone has filed an application for addition of party have been served with a copy. I don't know how it is maintainable. But the other part, your lordship had directed them to find out the returner. A report to be filed, my lord. Lordship passed an order on 29/7/2024. 29th.
Your Lordship,
29/7. Lordship's order. I have communicated to them.
Yes, for the DPSC.
Your Lordship, Mr. Bhattacharya is appearing on behalf of the DPSC, Your Lordship. Your Lordship, he is in another court 759. Your Lordship, praying for extension for 1 week, Your Lordship.
Was communicated much earlier.
Your Lordship,
That's all. Only to reveal the marks obtained by the
candidates whose names are included in the. Whatever the marks they have obtained, and what are the marks obtained by the panel. That's all. Super report.
But I have preferred an application for addition of parties.
A panel candidate.
Panel candidate. We have got.
Not taken any decision as yet.
Pardon?
We have not taken any decision as yet, which would affect you.
Well,
The order of the trial court.
well, I tell you, Lordship, the
Correct. We think we have to discuss that. Where is the?
Let's look.
Similar which করেছে আপনি in the
Oh, Malda, in similar matter, your Lordship has already passed an order dismissing the appeal. That I'm told.
So why you are apprehending?
No, apprehension only is that if your Lordship entertain it, then. Not the appeal.
Can we not entertain any regular appeal?
No, that's not. If you Lordship allow it.
How can you presume we have not applied our mind?
So that's why we are, because
Neither you are a necessity nor a proper party as of.
এই অর্ডারটা এগেইনস্ট স্টেট করেছে
Malda, I take your Lordship. Because I'm led by Mr. Gupta.
Yes, see, let him.
But I'm led by Mr. Gupta.
My application is for addition of party. The reason being,
Not deserve at this. On mere apprehension that if the court allows, I will be widely affected, does not seem to a necessary or support. We have not applied our mind on the merit.
true. But then, my lord,
If we think at the time that yes, we are going to upset the order, then definitely we will hear out the parties. I'm conscious of Om Prakash judgment.
kindly keep it pending then.
That's why we were not doing anything. We wanted a DPSC to disclose.
Your Lordship, praying for war.
I intimated them, we sent 2 speed posts because they will not take by hand. That's the main problem. They don't accept anything by hand. Lord, they should give me a advance copy of the.
Yes, yes.
Lordship.
What direction?
No, no, I bowed.
Of absolutely a futile exercise. To find that their authority will come at around 10:45 and hand over to them when the matter would be called at 10:50. How they can give you advance copy?
I am grateful.
Hundred one.
Alert 101, Milord, I am for the appeal.
And I appear for the state respondent.
Milord, matter is, Milord, previously the appellant applied for a special transfer on special ground.
Transfer matter.
Milord, few matters I have. Milord, applied for the medical ground, but they failed. But
I have a very good mind where you can. Yes.
But appellant failed to cross the hurdle of the CMOH. It is the not that kind of medical elements is there that appellant failed to cross that hurdle. But my lord, appellant very thereafter, my lord, since transfer is required, is a female candidate suffering, but admittedly she is suffering some ailments, but that not that type of parameter.
That element comes within the.
Yes. Gynecological disorder. But my lord, thereafter appellant applied on general transfer, which has been school forwarded the DI, but without NOC. That is why the DI has not considered.
Appearing for the state.
But I appear for this.
My lord, your lordship asked me to bring a judgment, my lord, shifting, whether shifting is permitted or not. My lord, kindly see your lordship decision is there, very recent.
The other day, your lordship was pleased to observe
I
that
have
there were some matters of this kind.
First application was on the ground of
Medical.
second application is also ground of medical.
Second and then second application is not medical. My lord, thereafter, when I failed to cross that hurdle, CMOH, then my lord, I shifted, I made an application on general ground. But what happened, interesting point, school forwarded it.
Brought this judge, but you have not brought the subsequent.
Yes.
Then I have, rather we have suggested there should be a time cap. One should not switch over. Here it was a general ground. Then we have said that second was on a medical ground. Then we say that if it is necessitated by a medical ground, if it is there, we have a reason subsequent to that application. Then you can't restrict the application of that. But here is a case, medical ground is more emergent situation than a general ground of distance. We have said that no, we should not, these frequent applications should be deprecated. I do not know in which matter nowadays I do not
Well,
remember the name.
only one point I want to suggest, only one point I want to
Nobody
bring
who told about it. Any matter, his matter, I have
that I have
said, I have recommended that the authorities should take into consideration. And if there is a time gap which is fixed, no further application on the same ground should not be there.
But my lord, still now when the appellant applied, there is no time, there is no mandate. So my lord,
say that the object and the intention is not very good.
my lord, intention definitely, my lord, one point on, my lord, school forwarded that application to the DI. Admittedly, my lord, when I made general transfer application, school forwarded to the DI. There is no discrepancy, but school did not issue the NOC. That is why the DI rejected it, asked the school, if you apply, if you forward this application, why not NOC? That is main context. So my lord, admittedly, my application has reached to the DI, but without NOC. So that is the lacuna. If the school rejected from their end, then I have no case, subject to correction. Since they have entertained my application only without NOC, that is the lacuna from the school authority. Since they have admitted, subject to correction. My lord, only kindly see the last application, which I am relying before your lordship. Admittedly, school forwarded the application, but defective application. Why that? Then intention of the school is in question.
Go by the 10% criteria.
Well, lord, kindly see.
Go by a 10% criteria. The school
No, I am within the 10% criteria. Yes, my lord. Kindly see page number 18, my lord, once of my application. Page number 18 application.
number 18, the repetition.
Yes, my lord, page 80, page 33, page 18 of the repetition, page 33 of the application. That is the extract, relevant Utsosri extract. My lord, I am relying. Is serial number 2.
Then 36. Okay, so page 36, you have not annexed this document. After page 32, get away 36. My brother's copy. Yes. Give it. Sorry.
My lord, may I come back with correction? Oh, please. Please.
Must have been last time you supplied, but you have not stitched.
Yes. Probably it has been.
Why you have not stitched? Ratu.
Well, let it be passed over. I shall do it. I might. Great. 5 minutes only. I'm taking 5 minutes first.
5 minutes. Let it be tomorrow then. Hurry.
I have to go somewhere else. In another court, my lord.
For 10 minutes then.
As your lordship pleases.
কি নাম আছে দেখো
Vipro.
দিস ইজ দ্য এভিডেভিট অফ সার্ভিস কার স্টেট না কার
Straight.
হ্যালো ইমপিউন্ড অর্ডার
DPSC. Board. West Bengal Board of Primary. ওরা তো একটা এই রেসপন্স কনসিডার করার কথা ছিল ইন্ডিয়ার জয়বীর সিং এই রিসেন্টটা কি বলছে এটা?
petitioner
হ্যাঁ এটা কি বলছে?
is the D8
কি বলছে
D8 qualified candidate of 2 years prior to date of appointment 14 to 16. It is equivalent to B8. Now, pursuant to that notification, the D8 and B8 are eligible for being appointed in a primary school. I applied. Appointment given 2017. Immediately thereafter, I made an application for getting A category scale of pay without having 6 months BS course. The impugned order to that extent something misconceived. Now, the authority did not take any step. Rather, made an order by the deputy director that I am to undergo 6 months BS course for getting a category scale of pay. But I challenge this. During the pendency of the writ petition, the impugned order passed. The learned judge first thing without considered that, and even then passed the impugned order. And I'm placing one after another. Now, your lordship's judgment just last week in respect of B.Ed candidate without having 6 months, authority is to consider. Now, in the meantime, what happened? Interesting case. I completed my 2 years DLED course for getting a category from the year 2019 onwards. Now, from 29 onwards, I am getting, no problem. My grievance is from the date of appointment till the date of getting that A category, I am entitled to and fixation. That is the case. Kindly come to page 1 after 1. First,
All in the court, in the domain of the authorities. They have to take a decision.
Well, kindly see paragraph number 4 of the impugned order.
West Bengal Board of
Yes,
Primary
yes.
Education has to take a
Let them take decision. Yes,
It's not really applied, it's fine. Court has
yes,
let them take a decision.
yes,
but
yes.
in respect of
Take a decision contrary to
Yes,
the rules. You have a remedy.
yes.
subject to correction,
So right has not been foreclosed.
not foreclosed, consideration to be made in respect of 2 years DLED course in terms of the Supreme Court.
Correct.
No, Supreme. Yes, kindly, I'm reading this.
Responded to the liberty to consider as to whether the petitioner's DLED course
DLED.
Yes.
obtained from the National Institute of Open
Open
Schools, which are all recognized by the board.
Yes.
of the judgment.
This judgment I brought.
I have also read it.
Yes, because
Says the B.Ed cannot be a criteria.
no. No, my lord. This judgment is otherwise.
What?
So
This
let
judgment says
respondent will take the
18
case.
months, not my lord Agnes Kumar, and 2 years. 18 months DLED is not recognized,
Yes,
but 2 years is recognized.
that is what is saying in case of this Jasbir.
Yes.
So Jasbir has to be considered in that.
But
light.
Jasbir is nobody's case. Jasbir, as per that judgment, I'm getting this.
So
you will be entitled.
Question of
why you are apprehensive?
Decision be
Jasbir really recognizes your right.
grateful. No, that
appeal is too early, my lord. Appeal is too
subject to
early.
correction, subject to correction. No, my lord. This is, I am getting the, nobody's case is this.
No,
Now from
which date?
From 19, on that date
From 16 or 17?
Yes.
from the 6,
On the date of appointment.
17, I am entitled,
You were appointed.
yes, 17.
Okay. So you want a retrospective operation for that?
Not retrospective.
আর তাই তো হলো তো।
Not
Has been granted from 2019.
in respect of DLED. Kindly see that there are two different of aspects.
So far as the bridge court,
this course for the purpose of the degree of DED, and this is DLED. There are some differences.
Right. No, let him take it. This is a.
This should be clarified to that extent, because I am not 6 months this course of DED. This is a 2 years training course. No, my lord, it is not recorded.
That she claims that she has earlier completed a 6-month degree course.
Not 6 months.
Between this.
This is not 6 months. That is the impugn. Well, that is 2 years training course. All persons having the DED degree are getting from their appointment. I am not. That should be, my lord, justice single bench interpreted. It is a 6 months pre-course. It is not the 6 months. Kindly come to my page 51. Yes. It cannot be 6 months pre-course. It is a total, my lord, misconceived concept. Page 51, this is my mark sheet, 3-star, 4 semester, session 14 to 16. This is equivalent of B.Ed. It's 2 years training course, like B.Ed. It is
B.Ed is not recognized there.
But D.Ed is the recognized. Kindly come to now, page 54.
Prior to that, matter, kindly come to 87, previous court's order. Previous court's order. Regarding this candidate.
I'm placing one. But kindly come to page 54.
These are all the semester 3.
No, page 54. It is government recommend. 27 October 2016.
Yes.
It is from Secretary West Bengal Board of Primary Education. Appointment notification of primary teachers by West Bengal Board by such and such. Column number 4. But kindly cease. Well, as per the NCT notification dated such and such, I shall place the notification itself. Candidates with DED special education, myself.
That been held by the Supreme Court is not wrong, because it says both the DED as well as the B.Ed.
B.Ed.
Both. No, B.Ed cannot be a ground.
Yes, subsequently modified. Who are the in-service teacher? Their case.
That the in-service teacher will not be affected by that judgment.
Yes, that is only respect of a B.Ed, not DED. DED is the permissible law. Page, yes, page, I am giving this. Page 57. And the notification of 2010 itself, I have also annexed.
So we are saying that B.Ed, it should be B.Ed, that's all.
There are the differences. But kindly come to page 57. Senior secondary or its equivalence, at least 50% marks, diploma in education. This is it is recognized by the government of India, NCT. Now, kindly come to page 65 itself, the notification.
Yes, the diploma.
Diploma in education, in special,
yes.
Not B.Ed. We are through. It is not dispute our case. Now, page 65, the notification itself. Got it 65. Column number B, 3B, training qualification, training to be undergone, page 65. In B.Ed, exclusively ineligible, but in our case, eligible. With D.Ed, special education, or B.Ed, special education. That notification, then we had to go 6 months this course.
That you have gone.
No, I have not done.
Oh.
So because of the fact, my lord, that kindly sees, thereafter notification itself, they have said so. At page 62 itself, I had to go. In respect of the B.Ed, your lordship directed our case to be considered from the date of appointment, whether I am entitled to get a category, but my DLED from 2019 cannot be touched, because I have made 2 years completion for getting a category, or intelligent impaired, 17 to 19. Kindly sees that only I had to go B.Ed, 6 months course in terms of. So your lordship,
They will take into consideration
but not in respect of my DL. They cannot touch. Now kindly modify the direction, and in the meantime, regarding B.Ed, whether 6 months undergo is to be done. And this
do not want. We can simply say that
Let the
whatever
rest.
the D.Ed or DLED, whatever you claim before him, let him take a.
Yes.
kindly sees the division bench. In respect of the
Not
B.Ed
that
also
he is not
same.
getting, he is getting from 19. He is
That is to be clarified. 2 years along with six. They have to consider.
Resend the thing. Let the respondent will give the reason. The premature appeal.
This should be clarified 6 months.
Premature or immature? What? Premature, my lord. My lord, before board's taken any decision, my lord, in view of the order impugned, my lord, he, my lord, came up before.
Impugned order of the authority, page 87, already they have taken a consideration. Respondent authority is the, my lord. Grateful to you. Much obliged.
Lordship,
I appeal for the appeal.
Lordship, in this matter, Mr. Shantanu Kumar Mitra is appearing for the state respondent, Lordship. He is engaged in courtroom number 26, Lordship. I'm pleading for not today. I'm pleading for not today, Lordship. No, Lordship. Okay.
Matter only the learned court passed the order directing the authority to consider my transfer application in the sense of finding of local arrangement, but without any time limit has been framed. As per law, it is a time limit is there. First, yes.
You have not seen the last judgment. So why you appeared in that?
The statutory rule says sometimes are there, binding time is there. Well, I have
indicated many things.
Well, I have got all these judgment I have read. But here,
There is no time limit which is given, then we say that there should be done within a reasonable period of time.
no, statute says sometime. Yes, I have annexed this.
1 week, 2 weeks.
Yes, it is annexed. It is annexed.
Don't
If
know.
your lordship,
Remember, I do not remember that.
21st December. Page, kindly see this within it because kindly see each and every authority. 21st December, each and every authority to do within certain time limit because statute says time bound manner.
December, no, we don't.
This is
have-
memo number 1122.
December 2021.
Yes, 1122.
I know. It's,
Memo number. Each and every authority. Within such time, because of the fact the next rules I have annexed. Memo number 9.
No, I got it.
Yes.
The tabular statement I am having.
Grateful. Now, my lord, kindly come to page 70.
Where is he?
Lordship, he is in courtroom number 26. Take it.
Call him within 10 minutes.
Lordship.
Call the next matter.
Oh, pass over.
Hundred four, I appear for the appellant. But I have this is my affidavit of service. That the government period office has been served. Now, let the
Out of time.
out of time. Yes, but section 5 is required to be filed. Yes. But kindly give adjourn the matter for 7 days, but
No section 5.
no, there is no section 5. But I have forgotten to file.
Section 5 is filed.
No. But I have not filed. But kindly give me 1 week time so that I can.
It appears that the instant appeal has been filed. Beyond the period of limitation. After this group is over. 105 is
105.
But I appear for the applicant
For the commission.
But I have filed one application for leave to appeal.
And I am appearing for respondent number 1. I am led by Advocate Firdaus Shamim, my lord. He is appearing in the Supreme Court, my lord.
Yes. Everybody has been served.
My lord.
You'd like to file your affidavit?
But I'll be praying for an interim order. Stay. But yes, but your lordship kindly hear me.
This is actually not a matter where an affidavit is required. The learned single judge was
going into the matter whether the teachers who are presently teaching are all properly appointed or not. In connection with that,
But I have not been.
Which order you are assailing?
I am assailing the order passed on 9th of July 2024 and 23rd of July 2024. Matlab, kindly turns to page 89 once. No. One order I am challenging, that is 23rd of July, page 199. If your lordship kindly, yes.
CPC inform whether any
Well,
steps have been taken against this
doubtful cases
person who is already there.
Thereafter.
The principal who is already there under suspension and in jail.
Now your lordship kindly turns to page 89. My name surface is 89.
What name surface?
Kindly turns to page 89 once. This order 9th of July.
July is here.
Yes. Now, kindly sees the order.
You have not challenged this 9th of July.
9th of July, kindly sees once.
both the orders are in the memorandum of appeal.
Both the orders are. Kindly
see that independent order can be assailed.
Yes, that is it.
I asked whether
Yes.
they are challenging 23rd. Then I reacted on 23rd. Now it's taking me to 9/7.
My lord.
My first reaction is we are not challenging this order. Maybe for reference he wanted to.
Yes.
No, but since it is in the memo, that is what I was trying to say.
Kindly do not on the technicalities. Kindly see the situation. Understood. Understood. Seize the order once. I am Bhavani Sharan. না কিন্তু কি করে থাকবে আমরা তো রিটটাই পাইনি সাত থেকে যা আপলোড আছে তাই দেখছি একটু মডেস্ট বলছি চ্যালেঞ্জ করা dear Lordship, kindly allow me for 2 minutes. Here the name of mine has surfaced. A writ petition has been filed by one of the candidate, challenging the selection process in 2016 SLST, where the upper primary group education upper primary teacher, where the selection process was assailed. Now, in that petition, she sought for appointment in the post of work education, physical education. I was appointed in 1989 in a school in Asansol. Now, your lordship kindly have a look to why I have got the information. My lord kindly turns to page 87. After this order of 9th of July, the Commissioner of School Education intimated me, page 87, to the District Inspector of Schools, Paschim Bardhaman, and to Mr. Bari's client
through the District Inspector of School Raiganj to intimate both the persons that your name is appearing in the list of doubtful candidates. But I have been appointed on the strength of the order of the High Court. But I approached the High Court for the first time in 1994. The High Court protected my interest and my appointment. The matter was going on. Thereafter, I approached the High Court for the second time in 2019. One of the honorable judge of this court passed an order to the District Inspector of Schools, Paschim Bardhaman, directing him to consider my appointment. He considered my appointment and gave the order of approval. Since 2019, I am appointed and approved. I am drawing my salary. Now the case is 5 more teachers. Let me complete. Let me.
1 minute more or 2 minutes? It said 2 minutes. We gave you 2. That's why.
Yeah.
2 minutes more.
Let me complete. At least 5-6 minutes. But kindly do not look into the watch. Kindly see what is there.
Yes, see what is there. That's why it's saying.
Kindly allow.
We are not into that. We are not interfering.
My lord is not interfering.
Saying not.
Oh, in Aja. Now, the case is that 5 more teachers have come to the court. This court. Everybody has got the order from this court. The DI has considered their appointment and approved their appointment. They have discharged their duty. They are retired. Once upon they have come to the High Court for release of the pension benefit. I am one of the candidates. But I have approached the court. I will request your lordship. Kindly turns to the petition once. What is the prayer? Your lordship kindly have looked to the prayer 121 of the writ petition. Grant leave to the petitioner so and so. I am not thereafter to issue a writ of mandamus commanding the respondents to and enable the petitioner to participate in the counseling process and give her appointment in connection with the recruitment of first SLST in the post of assistant teacher upper primary. My school is a high secondary school and my subject is history. So I have got no connection with the selection process of first SLST which held in 2016. I am a candidate. I was appointed in 1989. Now your lordship kindly says, therefore, this writ petition cannot bring me within the ambit of the writ petition. This is number 1. Number 2, kindly have a look to my appointment. Kindly sees my appointment. Kindly turns to page.
Appointment in 1989. Don't difficult.
Yes, page 21.
You don't worry.
Now, in 1989, I was appointed page 21 by the school management.
That too in history, no difficulty.
Yes.
Yes, my mind.
Now, thereafter, in page 24, if your lordship kindly sees, in 2011, a resolution was taken by the school management, which was forwarded to the. I'm here. Which was forwarded to the District Inspector of Schools, presenting 6 persons' name, 6 teachers who are not approved at that point of time to seek approval of their appointment. Now, thereafter, one after another, all the teachers have come to this court and all the teachers were approved by on the strength of the Honorable Court's order. Now, your lordship kindly have a look to the last order which was passed in my favor, allowing my writ petition in 2019 at page 58. Justice Rajashri Bharadwaj directed the District Inspector that as I am appointed in 1989 and working since then, the District Inspector may consider my case for regularization of service. This was done, considered and acted upon. The District Inspector has regularized my service. I am working over there. Now the difficulty is, in spite of the order of appointment, in spite of the order of approval, I have been dragged in a case where my lord, the selection process of 2016 has been questioned. Now, my lord, how I am, my lord, within the picture, and my lord, I have not been made a party respondent. I have not been served with a writ petition, and not only that, for the first time, my lord, by the order of the commissioner in 2024, 12th of July 2024, page 87, I was for the first time communicated that you have been dragged into a case and CID investigation has been ordered. But challenging this, but I have come to the court, and your lordship kindly sees the page. But just now I have mentioned page 199. Kindly have a look to page 199 once. It says 23rd of July 2024. It says, in compliance of the order dated 9th of July 2024, the president of the West Bengal Board of Secondary Education and other officers are before me virtually. Their further appearances dispensed with. Then, Mr. Swanso, learned additional advocate, additional government pleader, shall take instruction from the district director of public instruction.
What is the subsequent order which is passed? Before the earlier order.
Yes.
So it is there.
Now, thereafter, the members of the committee assured this court. Here I join the issue. The members of the committee means committee which has been set up to inquire into the so-called appointments, in which I am one of them. Mr. Bari's client is one of them. Members of the committee assured this court that the necessary exercise will be carried out to find out the doubtful cases of appointment of teachers in different government schools of the state. In response to notice, Mr. So-and-so, Mr. Bari's client, through his learned advocate, Mr. Bari, appeared. But I did not file any application for addition of party there. But I have questioned this order because the order has, on 23rd of July 2024, the order has said that in compliance of the order. So 9th of July is very important. But your lordship, kindly have a look to the 9th of July's order, page 89 once, for my satisfaction. And kindly see, how we have been dragged in the entire writ petition, where we have no connection with the writ petition. Our appointments were made long back.
Third time you are saying that our appointment in 1989, this relates to a selection process of 2016.
Lordship.
I cannot be robbed in. Those repeat. You a full opportunity of making.
Here that is why kindly see the names of mine is surfacing at page 19. The state shall issue notice regarding the pendency of the matter to say Mr. So-and-so, Mr. Bari's client and my client. Notices have been issued. I have questioned that now the CID investigation has been done. Thereafter, your lordship will find
from where you got that the notices have been issued by order?
Yes, by order dated 9th of July. Page 89. Now your lordship kindly turns to page 87. This is the notice issued by the commissioner on 12th of July. Reference is order dated 9th of July. Now your lordship sees next page, page 88. List of mismatched data.
Why you did not appear before the
Yes.
But I
notices were issued. Why you did not appear on 23rd?
23rd was a reference day, full court reference day.
What? So you did not appear?
No.
Why?
The court did not
From
10:30. From 10:30. Yes, it was reference day.
There was no reference date. Reference is done at 3:30.
It was we decided not to participate in the judicial proceeding from 10:30. No. It is the decision of the bar not to. I will kindly allow me for 1 minute.
The other candidate has gone before the single bench.
I will. But kindly protect me.
They
mismatched data of teachers as received from the Commissioner of School Education. Here my name surface. So mismatched data.
I say it's a doubtful case if you have been brought no right. As of now, nothing has been said against you. Nothing has been said against you. The moment you feel that something has impinged upon you,
Get finished. Only matter the I wanted to draw your lordship.
I do not want to make any comment.
No.
Any comment so far as your cases.
Yes. All of the
These cases, all are different things, I can understand.
civil court degrees, appeal,
I do
second
not,
appeal,
I
everything
do
was
not
there.
know. I do not know. I do not want to make any comment.
No, my lord, unnecessary dragging. When the civil court's order, I got the genuinity, they can always verify. No problem.
So that has
Yes,
been
yes, no problem.
detected by the.
That too, no
That's
problem.
all.
But when the civil court degrees, they are second appeal is
So
pending, whether
everything,
the-
if the genuinity of the document is
no
there,
problem, no problem, no problem.
that's why he's
That,
apprehended.
that can be verified. That can be.
I have been appointed by
But,
after the order of the High Court was passed.
It is what the court has meant in this, whether these orders are really genuine orders or not. Genuine means whether there was any proceeding of such nature, any number, whether such order was passed by the court. Somebody has fabricated the order and then
that is
what the court wanted to see. Anyhow.
Very good. But may I get this order? This server.
Dismissal now, disclosure.
But
The
can it,
urgent photostat certified copy, if applied for, be given to the parties within 2 days from date of such a
but instead of dismissal, can it be disposed of?
disposed of, which should be akin to a dismissal there.
But can it be? But otherwise, before the single bench, I'll be facing difficulty because of the dismissal.
You are before the High Court judge. They know what is the meaning of the word dismissal and disposal.
Very
good. Application seeking leave to appeal is hereby dismissed. Bolecho ওটা consequently
এই করতে বলেছে additional
বলুন yes next
pass.
Yes, Passover. After that, the Passover গুলো ডাকো লাইন ধরে
103
প্রথম থেকে
প্রথম থেকে
101.
Passover.
The 101
is
101 is
আর কি Passover আগে
তার আগে not today নেই
আচ্ছা Passover নেই তো
দুটো আছে
101 থেকে
101 and 103
ঠিক আছে দাও
101 টা দাও।
Why it was Passover?
But pass it over because teachers has not completed. But my case before your lordship, what happened, my lord, a candidate may not be a medical expert. I have some medical issue, but I do not know how serious that issue, which is why I made application on the medical ground, but is fails to cross the parameter of the medical ground. But then I have applied in the general ground, but school entertained my application. Since medical ground it has been not crossed, they forwarded the transfer application DI without NOC. I am agreed by this part. If they forwarded that application, why rightly DI remanded back to the school authority that NOC has not given?
Where is your residence?
My lord, I am residing at, my lord, Galundi, Birbhum. Galundi, Birbhum. My distance is, my lord,
Murshidabad, you are there.
Birbhum, my lord. Birbhum.
You are working where?
I am working in Birbhum also.
And,
But distance is, my lord, about, my lord,
and where is your residence?
my lord, Galundi, Birbhum. Distance is 72 kilometers.
Same distance. Yes, different. Mohammed Bazar.
Lord, I am facing real difficulties, my lord. I have medical issue and 71 kilometer distance I have to cross. I never opted the facility of general transfer
71 kilometer to your residence.
from my residence. From my residence, my lord. I never opted the facility of general transfer earlier. I am the one of the senior most teacher in the school, subject to correction, my lord. Only at least when my application has been gone to the tested before the DI.
One more, I appreciate it. And you can travel more than 100 kilometers for a checkup. But you cannot travel a 71 kilometers because that is the whole problem with you. You are living in Birbhum, you are working in Birbhum, and you are going to a medical hospital at Murshidabad and then getting yourself checked up at Murshidabad. And everything is done. Birbhum does not have a district hospital. Come to page 37 at the bottom.
Yes, my lord.
Murshidabad, everything is in Murshidabad. Second, you have done it Murshidabad, Laldigi. You have done it there, USG, everything. Then you showed it in Murshidabad.
My lord,
Then suddenly, one fine morning, I find at page 40, you are showing it in a Bolpur, Birbhum.
no,
Then Bolpur, Birbhum.
my lord, subject to correction, when I have my residence is there, that distance is minimized to the, my lord, in the Murshidabad. So I avail that facility, my lord.
100 kilometer is always a travel between a Suri or somewhere place to a Murshidabad town.
My lord, I am deciding in, my lord.
So, I have a strongest of reservations on transfer.
My lord, at least my transfer subject to correction. When the school entertained my application, it is not a case that school did not entertain my application. But there is some technical fault, my lord, they are not considered.
Doing
Lord, the school is also facing the problem that only single teacher is there.
Then you are gone.
Yes.
The moment you take single teacher, you are gone.
And
You have seen there is one order which
Yes,
was
yes.
passed
Third January
by me.
matter.
yes.
So, single teacher. It's the duty of the DI to take care of.
The I has to depend on the no objection certificate from the head of
Why
institution.
you will not grant a no objection certificate if the document shows that she is having.
Then let them come and say.
Who are you?
I'm the state. I'm DI.
I'm DI.
Yes.
Then
Let the school come.
I'm for the commission.
Then where is the DPSC?
My lord, school I have served, my lord. Your lordship directed me to serve, I have served, my lord. Service is there, my lord.
16/7, the item is delivered.
Yes, my lord.
103 টাকা
Obligation of the DI to send out the bathroom aid.
Yes, the next kindly excuses me, my lord. I was held up in court number 26, my lord. Kindly excuse. My lord, order impugned is page 90.
Yes. Now, subject to correction, my lord. That page 65, there are some time limits. Rule also says certain time limits are there. That page.
We'll hear out the matter. We have gone through it. We want to hear out the matter to find out the, the dichotomy amongst the various.
Because there is a provision that
Everything in the mess.
this has come, it says that within this time, every step or step-wise manner, everything is to be done. Let us see that how far there can be a synergy between all the provisions. When
And my lord, DI also.
bring all such
Sequence to be maintained.
3 weeks, my lord. 3 weeks. 3 weeks. Then my lord, fortnight.
that shows that you have not read the brief,
Yes,
you have not applied it at all.
Lord, I have read, my lord, we have complied with
You have not.
page 88, your lordship analysis.
Provision. It have been brought with relation to a single lordship. There it says that will make an arrangement.
DI will,
Look,
not the school.
find out that it is from a nearby school or whatever. There is a teacher who can go and teach.
Lord, page 88, your
Says that there is a time limit also given. Now we have to see whether these time limits have any bearing at that notification and how to create a bridge.
Lord, page 88, your lordship kindly sees for once. Page 88.
Another aspect.
Why on a general way? I know. That's why I wanted to.
Another aspect of the matter. Why the legislature consciously use the word the DI is to take all this arrangement? Because in the office of the DI, all the data in respect of the vacancy or teachers who are working there is there. Not the school. School, me being I am the school. I am not able to get that the teacher where is there, who knows his school. That is why page 72 kindly sees. Sorry, 69.
I will see.
Yes, 79 is memo number 9.
Page 88, your lordship, kindly see, have a look
Third
at page
paragraph.
88.
And DI has
My lord,
passed
we
the
have-
order.
We have directed
Page
all the
88.
my lord schools
Within 7 days, they are to
within the
arrest.
said district
Last
to
line.
send the name of assistant teacher of the same subject.
Data, that is what is saying, that the DR is having all the data where the teachers are there, where the teachers are not there. And who are the person who is the repository of all those informations? Ask somebody else that might be data.
My lord, we have asked for the names. My lord, we have asked for the names of the willing candidates.
He is referring, 21st December, and then there is a notification of
3rd January.
You have to create that, what is the synergy in between them. That there is a misconception in his mind, I would clear out that.
Because
Yeah, who
The day after,
are there, we'll have to.
my lord, it would come from Midnapur.
Whether notification of 21st of December 2021 at least 65.
Lordship, my lord.
And appearing on the notification dated 3rd January 2022 at least 70.
Much obliged.
The trial takes up next Monday, my lord. Trial takes up.
These are the two things.
Two things.
It's a pure question of
Law.
It would come from my lord, Thursday, then my lord, Thursday, my lord, Thursday.
sometimes the court must have exhaustion. Always, whenever the court suggests a date, lawyers always say, I have a problem. Sometimes the keep promising to the court.
I am obliged to you.
Lordship, my lord, your lordship, please.
All the time.
No, no, my lord.
Day after tomorrow. আসো না, দেখো না। দেখ here. Grateful to Lords. And unless this time limit is there, then contempt also would not lie. Let us come. Yes, everything to be interpreted by your lordship. Each and every matter.
Item number 106.
Get
106 করেছি।
Crossover for duty. 106 you are
My lord, I am appealing for the appellant. My lord.
appealing for appellate.
Appellant. My lord, this is also with respect to the well, this is with respect to that compassionate appointment. There is a delay. Affidavit of service কোথায়? My lord, we have already given the affidavit of service, my lord. My defects has been cured, my lord, as your lordship. That's my instruction. Sir.
But that's to be listed on the other side. They have.
My lord, affidavit of service has been filed on the last day, my lord. একটু দেখুন না। On all the respondents, my lord, we have. No, then if your lordship so desires, we may once again serve another notice that this will appear. my lord. Yes. Aparna Talukdar has been served. my lord, the first.
Something.
Yes,
The first one is Aparna, as I'm told, my lord, but we'll.
Four is one child.
Then we once again give a individual notice. If your lordship directs, my lord, we give a single notice, my lord, to them. No. Email address is not with us. We have given a physical copy only. A hard copy of us. The college is having email ID. There we have sent. Yes. But Corona we didn't give. There is a delay of 242 days. According to our calculation, my lord. My lord, from paragraph 6 onwards, my lord, we have explained the. My lord, paragraph 6 onwards, my lord, 6, 7, up to 8, 9, 10, 11, 12. No, up to 10. 10.
Very bad, after hearing this, no explanation on the other side. Despite this circumstance.
My
lord, this item 107 and my lord, item 110 or my lord, these are the appeal from the same impugned order. My lord, maybe take this matter together with 110, your lordship. 110, my lord. These both may be taken. Well, well, separate advocates are there for the state also. My lord, actually, I'm led by Mr. D. N. Roy. My lord, he's in court 11. My lord, he's coming, your lordship. So, my lord, Mr. D. N. Roy, my lord, actually, your lordship. No, man, not taking adjournment, but it can be taken together with 110. My lord, just I'm saying a short part. My lord, your lordship, my lord, I'm not saying.
110.
My lord, this was actually, my lord, this is a pari incurium order of, my lord, one day. Order first thing, my lord, there were two specs are there, my lord. First, we are, my lord, first
gone into the my lord, main matter. There is a item number 107, my lord. There is a delay of 250 days.
Yes, that my lord, condonation of delay application.
110, I have not.
Second, my leave to appeal is also filed. It's showing defective, but a leave to appeal is filed.
But I have not subbed the copy of the leave to appeal.
110.
110.
110. 110 is leave to appeal and out of time.
My lord, your lordship, actually, my lord, we are not the petitioner, my lord, we were not the parties, my lord, that. My lord, they have not filed opposition.
107 also, my lord, similar.
Under 10, your lordship. Well, there was a direction, your lordship.
110.
But they have not filed anything, my lord. No, they are saying not sub.
No, I am not appearing for the state in this matter.
My lord, I am appearing.
No copy.
My lord, it is direction to give the that vote
Board is my lord.
My lord, board is supposed to give opposition.
My lord, your lordship kindly, my lord, extend the limited time, my lord. Your lordship kindly, my lord.
My lord, I am for.
I know.
109. Under 109.
How much seat is it? But I am appearing.
I am for the respondent writ petitioner.
I am appearing for.
যেটা লিখেছিল পিটিশনের কপিটা কোথায়? কপিটা কই? এখানে আছে। মুশকিল একটা জায়গা এটা চলো।
107. There is no section 5. At least we have not been.
Hello, Mr. Kaur,
Yes.
for whom? Mr. Kaur sometimes appearing for the university, sometimes appear for the.
I appear for the client who briefs me. Yes. That is
okay,
precisely I wanted to point out.
Well, it's all right. It's all right. Hello, this is an application. This is an. Right on. So, but there is something I will come to later in the next one matter. My lord, there is this direction was under Article 142.
179 days, sir.
My lord, but problem is that it was a direction given under Article 142 of the Constitution of India. I know that, my lord, but there in this matter, no, my lord, if we can come to page 68.
Impugned order is dated 4th July.
I know that. It is. I'll go through my petition first. Page 68. Well, what was the back? I'll tell you just. Justice Vishwanathan pointed out that why he was directly came up against this single bench judgment. So then I withdrew the writ and the liberty is given to approach this court. So therefore, this order has been passed under Article 142 of the Constitution of India.
What does it?
But it means the delay portion, because after this order, that's why I'm, because I know that section 1, I could have filed, or I can, one paragraph could have been there that it is because of such and such, not on time it has been filed. That I could have done. And let us. No, my lord. But in view of that, there is a confusion. In view of this order, whether I need to file on section 5 application or not. If my lord. Yes, I will file that one. That okay, let liberty may be given to file it. section 5 tomorrow by tomorrow. Tomorrow by tomorrow.
Because service not completed, my lord. 111, my lord. I am on behalf of the applicant, my lord. Day after tomorrow, my lord. I pray. Yes, my lord. Because of the fact, my lord, 30.
Service is not complete. They have to not this week.
112.
112. I am for the appellant, my lord. This matter led by the Lord Advocate General, my lord, praying for 2 weeks. My lord,
Senior ground, look down.
my lord, and copy has not been shared, my lord. The memo and the stay application not shared, my lord. My lord. 2 weeks, my lord. My lord, advocate in trial court also, my lord, also had argued the matter.
The respondent is petitioner. The respondent is petitioner.
Now he has come.
Let a copy of the memo stay. Not this.
My lord, 2 weeks, my lord, my lord.
113.
Give him a copy.
113.
My brother is sitting after 2 years.
114.
114. I am for respondent numbers 1, 2.
I am for the
three.
My lord, we are employees of West Bengal University of Animal and Fishery Sciences. Now we filed a writ petition, my lord, seeking the pension, general provident fund and all other benefits which are, my lord, applicable to the normal or regular employees of the university. Now there was a memorandum of understanding, my lord, between the council and the municipality, whereby, my lord, it was decided that all these benefits will be given to us. Initially, we were appointed, my lord, in Krishi Vigyan Kendra. Now, these each district has one Krishi Vigyan Kendra. These Krishi Vigyan Kendras, my lord, were taken over by the university. A memorandum of understanding was signed, and thereafter, my lord, pursuant to subsequent notification that I shall show, my lord, your lordship will find that the university was under the obligation to treat us as a regular employee of the university, and those benefits which has till date that has not been given. Now, what they have done in the meantime, my lord, they are giving us the contributory provident fund instead of pension and general provident fund. Now, there are few documents, my lord, admittedly those were not placed before the learned single judge. Now, this writ petition was taken up for consideration, and the learned single judge, my lord, directed the state and the university, my lord, to, my lord, consider the terms of the service condition of the petitioners. Now, these terms and conditions, my lord, are already there. There is no scope to consider these service conditions. Therefore, my lord, the only issue is, my lord, whether the university has violated the memorandum of understanding and 2-3 circulars, my lord, issued by the state government. This is the sum and substance of this appeal. My lord, your lordship, kindly, my lord, may I just place the impugned judgment, which is at page 376. Thereafter, my lord, I shall place those documents, my lord. 376 is a short judgment, my lord. This is dated 5th of September 2023. Second paragraph. The petitioners are employed at various Krishi Vigyan Kendros referred to as KVK under the West Bengal University of Animal and Fishery Sciences, Kolkata. The primary prayer of the petitioners, as elucidated by the learned advocate representing them in this writ petition, is the disbursement of their retirement entitlements, including pensionary benefits. The petitioner asserts that they should be recognized as regular employees of the university and accordingly should receive the associated benefits. Mr. So-and-so, the learned advocate representing the petitioners, contends that the university has appointed these petitioners and accorded them the advantages of career advancement scheme. The petitioner have been treated as regular employees by the university and consequently, the university is obligated to provide their retirement benefits, including pensions. Mr. Nondi cites a memorandum of understanding between the Indian Council of Agricultural Research and the university, which governs the terms and conditions of KVK employees under the university. According to Mr. Nondi, as per clause 6 of the aforementioned memorandum of understanding, KVK staff should be treated on par with university employees concerning privileges, amenities, and facilities provided to other university staff. Hence, the petitioner should be entitled to benefits similar to those of regular university employees. Now, first paragraph, I'll kindly skip over. However, according to the affidavit submitted by these respondents, ICAR grants aid to the university for the operation of KVKs and the university appoints KVK employees exercising administrative control over them. Respondent number 5 maintains that as KVK staff is essentially university staff, the matter of provident fund for KVK employees is to be determined by the university with reference to clause 8 of the memorandum of understanding. It is stated that council will not bear the cost of pension, contributions, leave salary and any other retirement benefits incurred or committed by the grantee need in place of contributory provident fund or general provident fund. The university's affidavit asserts that KVK is a project funded by the ICAR and assigned to different agricultural universities. And the ICAR sanctions KVK posts, not the state government. The appointment letters to the petitioners clearly state that they are temporary employees holding position. My lord, in this case, the state has no role.
That is what it's true.
My lord, that is a wrong finding, man.
You have already read it. I just thought that you are passing some other order.
No, no.
The coordinate bill. You have gone through that.
Yes. Now, here, my lord.
IKEA is the current scheme, that is everything done now, that scheme that is expected or have already expired by months of time. Now what will happen to those? City has taken over.
Yes.
By whom?
My lord, university is, my lord, should be, my lord, act in terms of the funded by the by it's an autonomous body, it receives grant.
From where? Not from here. Where?
Well, from the central government.
So
Now the issue is, my lord, here the issue, my lord, involved in this writ petition is that whether the university is under the obligation to adhere to the memorandum of understanding and its own act and statutes. This is the issues, my lord. They have violated the provisions of the memorandum of understanding as well as, my lord, their own statutory provisions. Yes. Yes.
Of those Kendros.
My lord,
Coming under the university, under the recognition of the university.
my lord, including the service conditions of the employees of those Kendros. Now, these conditions.
There is no rule.
My lord,
That and statute. If there is a conflict, then
Well, today we should be treated as the employees of the. I'm sorry.
there is an MOU and there is a statute.
But there is no conflict. No conflict. There is no conflict. There is no conflict. The memorandum of understanding, my lord, was, my lord, framed following the statute, and statute says that.
Statute is there.
My lord, that is the issue. The university, my lord, has acted stepmotherly, and my lord, for reasons best known to them, they have not extended those benefits. That is the exact that I am showing, my lord. Your lordship, kindly consider those documents.
But
The decision, my lord, already they have taken by extending the benefit of contributory provident fund. That this decision has already. Well, I am led by Mr. Gupta. Let him.
The issue is, if I may. If your lordship kindly permit me tomorrow to take up this.
No, madam will come back tomorrow. Please. এইটার থেকে সরি হবে। এই ফার্স্টে রাখবে। হ্যাঁ দিলাম।
I have just now got one matter, district court number 26 also tomorrow.
Day after?
All right.
Please.